all persons having anything to do before the Honorable the Justices of the Appeals Court, now sitting in Boston, far and within the Commonwealth. Draw near, give your attendance, and you shall be heard. God save the Commonwealth of Massachusetts. This court is now open. Please be seated. Good morning, Your Honor.
Good morning and welcome to the Appeals Court. I am William Meade. With me today are Justices Sachs and Hodgens will be the panel for all of the cases. As you know, each side gets 15 minutes. We've read everything. We do not entertain rebuttal. My best advice is to get right to the point. And with that, I'll call our first case, 22P 1015, Commonwealth versus Novus. Mr. Crouch.
Good morning, Your Honors, and may it please the Court, Andrew Crouch on behalf of Edwin Novus, who appeals from convictions out of the Worcester County Superior Court. I'd like to begin today by addressing the primary issue in the brief, namely the sufficiency of the government's evidence as to the identity of the shooter. We would suggest that the evidence establishes the possibility or even the probability that Mr. Novus could have been the shooter in this case. What the evidence does not allow, though, is for that conclusion to be drawn beyond a reasonable doubt. And we would suggest that this case falls into sort of a narrow sliver of cases along the lines of Mazza and Morris and Salemi, where the evidence, despite there being evidence of participation or involvement or other circumstantial evidence related to the offense, that there was insufficient evidence to get it over the line to reasonable doubt.
His fingerprint was found on the murder weapon, right?
Yes, so I'm happy to discuss each of the different parts here.
That's pretty compelling evidence, isn't it?
It certainly is, but I think when we look at a case like Morris, for example, what happens here is we have fingerprint evidence, and this is sort of taken out of order, but I'm happy to address that. The fingerprint evidence is, obviously there is, Mr. Novus's fingerprint is found on a firearm that's located within a short distance of the Tropagala off of Benefit Street, but in similar...
Which was the street that the shooter ran down after the murder.
Correct. So all of this is within, and certainly taken in the light most favorable to the Commonwealth, this is all the evidence, and this is the most favorable evidence in the Commonwealth's interest here. But that particular piece, that firearm was found 5 to 6 days later, and as Morris suggests, and as the examiner, forensic examiner in this case said, we don't know when that fingerprint was placed onto the firearm. Just as in the Morris case, where the Supreme Judicial Court, in somewhat similar circumstances where there is a bevy of other circumstantial evidence supporting Morris's involvement in that crime, there was a mask that was dropped, a clown mask that was dropped on the front stair or the first floor stairs of that house where there was a break-in to a place where drug sales were being conducted. The defendant, who fits the description of one of the assailants in that case and has a whole sort of other information connecting him to that crime, including telephone contact with 2 individuals, repeated telephone contact with 2 individuals who were then arrested and convicted of first-degree murder in that case. He fits the description. His mother's car fits the description.
Yeah, but there was nothing that put him at the scene. That was the issue in Morris, right? All they had was the mask with the print on it.
They had the...
Unlike here, there were witnesses who put the defendant at the scene, right?
I would suggest that this case is in a better posture than Morris for those reasons, like Your Honor is saying. While separate from Morris, Mr. Novus is undoubtedly at the scene here. The difference between the cases that I'm talking about here and ours is that we actually do have an eyewitness in this case, and that eyewitness is a trained police officer who has been dispatched to the scene of the Tropagala nightclub at 1:45 a.m. for the purpose of actually trying to prevent or try to witness or observe the scene, because this is a place where it's a high crime area where shootings, fatalities have occurred before. He is there. He has a clear line of sight within 25 feet on his arrival of the front door, where he sees the commotion. He sees the shooter pull something out of a pocket or out of his.
Can I ask, if we disregard the testimony of Officer Tolson, is there some fatal contradiction among the other accounts by the other witnesses that you say renders the evidence insufficient?
I think it, while certainly juries are in the position where they're to judge the weight of the evidence and the belief as to the people who are testifying, here, this isn't, as I said, this is a very unusual case because we do have that eyewitness, and along the lines.
Okay, but if we disregard his testimony, is there something insufficient or fatally contradictory about the rest of the witnesses or
So the other witness, sir, the other witnesses who testify in the case, specifically the most important ones being Vargas and Gonzalez, their testimony sort of evolves from the time of their initial.
Is there a yes or no answer? I don't mean to be impertinent, but I assume you're going to say yes, there is some fatal contradiction. What is it?
Okay. So what I would suggest is none of those individuals see the shooter in this case.
Vargas testifies that she sees the defendant across the street, and then he runs towards the bar, and then shots are fired.
So she says that she sees him, but she also says that he is not pursued at that point. There are other inconsistencies with her testimony. There's testimony with regards.
Yeah, but you know, Mr. Crouch, and perhaps this is what Justice Sachs was getting at, is those are things that juries sort out. If there's conflicts in the evidence, it doesn't render it insufficient.
Certainly, and that is the jury's purview. But as I would suggest in this case, we do have some other cases where the Supreme Judicial Court has taken a close look into evidence that looks on its face, the circumstantial evidence looks on its face, to be enough to get over the line. There are certain parts here, and I think that
you mentioned slumming before. Is that the shooting in the diner?
That is, I don't think it was. I think it was a Chinese food restaurant.
Okay,
it was the Halloran case.
But they didn't know who. There was two possible people there shooting.
Right.
Yeah, but that's not what we have here.
Well, it's two possible. We know that in that case, the similar sort of thing is that they know that Mr. Salemi was present on the right hand of the victim at that particular time. So we know that he was also present in the Salemi case. Here we have, and to keep coming back to it, we have an officer who actually witnesses. The jury would have to fully disregard Officer Tolson's testimony to be able to get to this point. And I know that generally speaking, that is within the jury's purview. But here, I would suggest that you can't get. It's just entirely inconsistent with the accounts of others, to suggest that everyone testifies on one hand as to the description of Mr. Novus.
Some of the contradictions are very striking. The jury has to choose.
They have to choose. The contradictions here, though, it would have to basically entirely disregard Officer Tolson, the sole identification witness in this case, who sees an individual who is entirely inconsistent, and he acknowledges this at trial.
It's not an ID case as much as it's a circumstantial case.
Correct.
So there's also a lot of evidence of hostility between them. All right, and then there's also the Nieves or Neves, that's the neighbor. There's a lot of consciousness of guilt testimony, too.
There's certainly consciousness of guilt and motive, and as we know from the case law, those two, even when combined, are not enough to get over the line.
But they help in this circumstantial equation.
This is all taken in the light most favorable to the Commonwealth, and there's not to say that there is not a possibility or even a probability that Mr. Novus committed this offense. That is, I am acknowledging that. What I'm saying is it does not get over the line to the point of reasonable doubt based upon it's not just inconsistencies. Officer Tolson, who is there, who has full witness of the events, who then goes on to write a report immediately afterwards. He is consistent 20 years later in his testimony. He says what he sees.
Why would the jury have to conclude it was just a remarkable coincidence that they found a gun, excuse me, with the defendant's fingerprints on it on the street where the shooter was fleeing the scene on?
Because at that point, there is no evidence in the record as to when it gets there.
That's true. But I mean, does Mr. Novus go around depositing guns around on various parts of the streets?
The record is silent as to how it got there. We have a 5 to 6 day window in which that weapon is not found, despite the police doing an active search. This is a very short distance away from the Tropicana nightclub.
I thought it was fewer than 5.
I believe it was 5. I think it was December 21st to the 30th. So whether that was 5 to 6, I'm not entirely sure.
But you'd agree that, a firearm is not an item that's typically carelessly discarded, right?
I would suggest neither in Morris was a mask worn during a robbery.
There's a big difference between a mask and a firearm, isn't there?
They're both implements used during the criminal offense, though, and that mask, which was used in Morris during the crime, during the house infiltration, has the defendant's print on it. There's an assortment of other evidence that suggests that individual in Morris was also involved with the underlying criminal case. Here, I would suggest that because of the evidence in terms of Officer Tolson, we are in a situation that is somewhat similar. The facts are slightly different, but I think it falls within that vein of cases where there is insufficient evidence to get that over the line.
You keep mentioning Officer Tolson. Do you think his testimony carries any additional weight because he's a police officer?
I don't, Your Honor, but he is trained, he is there for a reason. He is the one who is consistent in his testimony from the very beginning when he writes his police report all the way through 20 years later, which cannot be said of the other witnesses. He testifies that he sees somebody who is 5'8" to 5'11". The defendant is 6'2". He describes him as light-skinned. Everyone else describes him as either, including him, the officer at trial says Mr. Novus is medium-skinned. Others, including the victim's brother, calls him dark-skinned Hispanic. He says that he has a short-cropped haircut. Others say that he has an afro. They say he's wearing a white T-shirt. Everybody else, even the victim's friends, say no, he's wearing a plaid shirt that is located at the house. There's all of this evidence that suggests that he sees the shooter. The jury would basically have to say, he is entirely incorrect about what he saw, and we're going to go with the circumstantial evidence of the others who did not actually see the offense. Now, is that possible as a result here? Certainly it is a possibility, but I would suggest that that does not cross the line into reasonable doubt. Briefly, to just touch upon the second issue, I don't know that there's going to be much dispute with regards to Guardado. The Commonwealth conceded that point. If the court has questions, I'm happy to answer that. Otherwise, just very briefly with the third point, the unpreserved closing argument error. This is a case, as we would suggest, even though on their face, cases like Mazza and Morris and Slemmy don't necessarily always look like close cases. The courts there describe those cases as not actually having overwhelming evidence. In cases where there isn't overwhelming evidence, as we're suggesting was here, any sort of push over the line, and we understand this is an unpreserved issue, any push over the line is something that could tilt the jury in favor. In terms of sympathy here, there was these repeated references to a baby in this case, and for no real relevant purpose other than perceive that as...
Mr. Crowder, the defense counsel clarified that it was not the defendant's baby. And why isn't this entirely collateral to what's going on here?
Because
you said it went to the heart of the case, and it just does not go to the heart of the case.
So what I'm suggesting is it's going to the consciousness of guilt evidence here, which, as we're talking as Your Honor noted, this is a circumstantial evidence case, and this helps strengthen circumstantial evidence in terms of the consciousness of guilt argument. Besides the fact that Mr. Novus leaves the scene and then from there leaves the apartment and is not seen again, though there's no evidence in the record as to where he went for 20 years, one of the suggestions that is made repeatedly here is that he has essentially abandoned this baby that is either his or that he's taken care of. That evidence doesn't seem to have any other relevance in the record.
What do you mean there's no evidence as to where he is? Didn't he go to the Dominican Republic?
For 20 years, we don't know where he was until he was...
He got hauled back from the Dominican Republic.
Yes. We just don't know when he got to the Dominican Republic. We don't know when he left the city, the town, the state, or the country. But here we would suggest that that evidence, again, is just another part of the factor of weighing in terms of reversing convictions here. If the court has any additional questions.
Seeing none, no, thank you.
Thank you.
Ms. Borges.
Good morning. May it please the court, Danielle Borges on behalf of the Commonwealth. The Commonwealth respectfully asks this court to affirm the defendant's convictions other than the carrying a firearm without a license and possession of ammunition without an FID card. Talking to the defendant's first claim.
Hold on. Wait a minute. All right, no, we got it, all right.
Good. To the defendant's first claim, the Commonwealth produced ample evidence to support the convictions of murder, armed assault with intent to murder, and assault and battery with a dangerous weapon. The evidence presented by the Commonwealth, it's supported by reasonable inferences that the jury were entitled to draw. The jury could find beyond a reasonable doubt that the defendant was the perpetrator as charged. they could have reasonably concluded that the defendant was at the Tropicala nightclub on December 23rd, 1999 into the early morning hours of December 24th. They heard he was outside the nightclub around closing time, and they could infer from the evidence that he pulled out a firearm, shot Mr. Masonette, and shot and killed Mr. Nicasio. Not only was there evidence suggesting that the defendant had been identified as the shooter, but the Commonwealth additionally provided the jury with evidence allowing them to conclude the defendant had motive to commit the crime as well as opportunity and had manifested consciousness of guilt. And the trial judge properly denied the defendant's motion of required finding at the end of the Commonwealth's case.
Gonzalez said that the defendant told her that he was having, excuse me, issues with Pee Wee and his friends, and the defendant had recently jumped by them. Did the group that jumped him, did that include the victim?
Not to my understanding. I think it was Mr. Masonette, who was a member of the Kilby Street gang. I believe it was them, but I think Mr. Nicasio hung around with them and was there the night of, but I don't think he was part of that group that.
Was there evidence that he was in the same gang?
Not presented at trial. Are there any questions on the first issue? If not, then the second issue, as discussed, the Commonwealth is conceding under Guardado. And briefly touching upon the defendant's third argument regarding opening and closing statements, these statements, which were not objected to, were proper and do not create a substantial risk of a miscarriage of justice.
But I'm stuck, and the prosecutor said that the defendant and Ms. Pina it was their child.
That was an improper statement. It was.
Oh, so when you just told me that the argument was proper.
The argument was proper, where I believe that the prosecutor said that was at an opening, I believe, and then Ms. Neves testified that it was the sister-in-law's child, but the sister-in-law, the defendant's brother, and the defendant all lived together. So where Ms. Neves testified, no, it's not, and I believe she specifically answered on cross, this is not the defendant's child.
Right. No, it was clarified. And I don't know if there was a misunderstanding by the use of they, since there are three of them living there.
Yes, it seems that it was maybe potentially misconstrued once, that it could have been the defendant's child, but then it was clarified, and then it wasn't referenced again in closing that this was the defendant's child, just that the child who lived in the same apartment as the defendant was left with Ms. Neves for 5 months following the incident.
Which really doesn't relate to the murder.
No, it doesn't, but it was just a summation of the evidence, which was admitted at trial without objection. It wasn't the focal point of the opening or closing. I believe in each instance it was 2 or 3 lines out of closings and openings that span 6 to 10 pages. So they weren't excessive, and the jury was properly instructed to determine facts based solely on the fair consideration of the evidence, not to be swayed by sympathy. So there was no error, let alone a substantial risk of miscarriage of justice, where all of the proper instructions were given after the closing. Are there any further questions? No? Based on the foregoing, the Commonwealth will rest on its brief.
Thank you. Thank you both.
Thank you.
The next case is 23P 1174, Commonwealth versus Lugo-Marchant. Yes, please, Ms. Bluford. Before we get started on this one, I'd ask you to not use the victim's name in your argument today, because it is being broadcast over YouTube. We'd ask you to refer to her as the victim, or to use her initials, or employ some sort of pseudonym, but otherwise, please do not use her name.
Okay. Yes, Your Honor.
And her name, which you used repeatedly in the brief.
Okay. All right. Good morning, Your Honors. May it please the Court, my name is Attorney Claudia Augustin on behalf of the appellant. In our brief submitted on January 29th, 2024, we raised 4 issues that we would like to present today. The first issue being whether there was sufficient evidence presented to the jury to find the defendant guilty of indecent assault and battery on a person over 14. We would like to argue that the Commonwealth failed to meet its burden of proving beyond a reasonable doubt that Mr. Lugo-Marchant committed an indecent assault and battery. The definition of indecent assault requires not only the unwanted touching, but also that the act be sexual or lascivious in nature, as established in Commonwealth v. Gunter, which emphasizes the necessity of sexual intent in such cases. The Commonwealth's claim of sufficient evidence for indecent assault and battery is flawed. While the Commonwealth cites Commonwealth v. Mosby and the Levine case to support the idea that touching a thigh may be indecent, they overlook a crucial context. These cases involved more direct, unambiguous sexual contact than the alleged actions in this case. The Commonwealth's argument hinges on the suggestiveness of the situation and the defendant's comments.
Well, it doesn't hinge just on that. That puts the comments in context. He put his arm up her leg and touched her thigh. And then said, is it okay if, after saying this sexually suggestive things, then he said, is it okay if I continue? Which to me means he not only understood what he was doing was sexual, but he also understood it was inappropriate.
Well, what we're arguing here is compared to, for example, the Mosby and Levine cases where the contact was more overt in terms of its sexual intent. What we're arguing is that the evidence presented in this case, this alone does not constitute sufficient evidence of an indecent touching as defined by Commonwealth BIENVENIDO. So the ambiguous nature of the contact coupled with the lack of explicit evidence.
I don't understand the ambiguity you're referring to. He starts off with an inappropriate conversation about whether she's married or has a boyfriend, and then he starts massaging her foot, and then he works his hand up her thigh, up her leg, and then onto her thigh. That's not ambiguous.
Well, actually, one of the later issues that we are presenting is the lack of assistance of the defendant's counsel, because there was not, the defendant did not have the opportunity to present evidence which would have which would have shown the ambiguity of the act that was being alleged by the.
When was he denied an opportunity to present evidence?
That's actually one of the points that I would like to raise.
When was he denied the opportunity to present evidence?
Specifically, he was not able, the defendant's counsel did not, excuse me, the defendant's counsel did not cross-examine the victim, and so we find that had the victim been cross-examined, more information in terms of some gaps in the information that she was alleging and presenting would have been raised at the trial.
Well, he cross-examined her to some extent, didn't he?
Well, the defense, what we're basically presenting is that the defense counsel did not adequately assist the defendant in this case.
So what could he have done differently that would have perhaps produced a different result? How did he deprive her of, the defendant rather, of an otherwise available substantial ground of defense?
A lot of the issues come about in terms of the feasibility of the actions that were alleged by the victim. So in terms of, if she's sitting in the back of the car and he's driving, how would certain things have happened as she's testifying that they occurred, in terms of would it be reasonable for somebody who's driving a car to have performed these actions at the same time? And also there was a reference to her, she was leaning forward. What was the reason for that? What was other conversations that were taking place? Just to clear some of there were holes in some of the testimony that the defendant's counsel unfortunately did not raise, and so that is one of the issues.
But your problem, your glaring problem is there was no motion for new trial here.
Right.
So this is, as you acknowledge in your brief, this is the weakest form of ineffective assistance, and it is the weakest form of it because these claims, the factual basis for your claims, are not indisputably on the record. They're not on the record at all.
Okay, yes. All right. If you have any more questions on the first issue, I would like to move on to the second issue, please.
Go ahead.
Okay, thank you. So the second issue is whether the prosecutor's closing argument impermissibly bolstered its case and prejudiced the jury. So what we would like to present is the prosecutor during the trial significantly prejudiced the defense and compromised the fairness of the proceedings by repeatedly referring to the victim as the victim.
This is just in the closing, right?
Yes.
Okay.
Yes,
And
this is-
the judge granted the defendant's motion to preclude the Commonwealth from referring to her as the victim, except the judge said, but you can do it in closing argument. Is that
Okay.
right?
Well, what we're basically just want to show is that this is an improper characterization because, as noted in Commonwealth v. Sargent, it suggests that a presumption of guilt, which is fundamentally contrary to the principle of innocent until proven guilty. So if during the closing argument, the individual is being referred to as a victim prior to the jury having the chance to deliberate and render a verdict, it gives the connotation that this is already a victim, which would mean that the defendant is in fact guilty.
Well, it turns out that prosecutors are actually advocates, and they get to argue their side of the case. And their side of the case was here to convince the jury that this man had committed a sexual assault, and the woman that testified was the victim of that assault. That would come as a surprise to no one in the courtroom,
Okay.
especially the defendant, that this person is alleged to be the victim of his crime.
There are other comments made by the prosecutor that we would like also to address. Regarding the victim's behavior after the incident, there was an implication that it is typical for victims to freeze. We feel that that lacked evidentiary support and was not properly substantiated. This kind of argument, which is actually criticized in Commonwealth v. Welton, serves only to bolster the credibility of the witness without a factual basis and therefore mislead the jury. The prosecutor also misrepresented the nature of the victim's identification of Mr. Lugo-Marchant, exaggerating her certainty when in fact she had expressed doubts during the investigation, highlighting significant discrepancies that should have been explored further. While the Commonwealth argues the remarks were a fair response to the defense's line of questioning, the comments regarding the certainty of the victim's identification and lack of motive to lie, as highlighted in Commonwealth v. Sanchez, crossed the line from permissible advocacy to improper bolstering of the victim's testimony. Commonwealth v. Robideau emphasized the need to examine closing statements within the entire context of the trial. In this case, we argue that the prosecutor's emphasis on the victim's certainty, despite her own statement that I'm pretty sure, and the assertion of a lack of motive to lie, were unduly prejudiced. If there are no questions on this, I'd like to move on to the third issue. Thank you. The ineffective assistance of the defense counsel in this case is very concerning. As established in Strickland v. Washington, a defendant's right to counsel includes the right to effective assistance. Trial counsel's failure to file a motion to suppress the out-of-court identification was a significant oversight.
On what basis should the counsel file that motion?
On the basis that the photo over array was not properly conducted.
In what way?
As far as I understand it, just in the sense of how the photo array was, how the photos were chosen, the methodology behind the photo array, and then also the detective who conducted the identification process with the victim was not the same detective who wrote the report on the issue.
Yeah, that's the Silva-Santiago protocol, that you do it with a blind. And there was actually a lot of testimony at trial that he followed the right procedure. But again, there's, aside from the testimony that would lead one to believe that it was done properly. There's no other record. We don't even have the array.
Sorry, what was that?
We don't have the array. We don't have the testimony of the people that were involved and how it was done and how the photos were selected.
Well,
We don't have findings from the judge.
Right. So that's something that, we're just arguing that the defendant's counsel did not appropriately deal with that issue in a way that would have been beneficial in assisting the defendant in his case. And that's one thing. I mean, the other issue also was that the investigation portion, like I was saying earlier.
And he had 3 lawyers. We don't know what they did or didn't do. There's no record of it. Or even more importantly, there's no showing by you, and there certainly couldn't be on this record, on direct appeal, that an investigation would have uncovered something that was beneficial to the defendant. We don't have that.
Right. Well, I mean, and just in conferring with the appellant, the appellant in this matter, there was a lot of things that were not done by the defendant's counsel.
There's a great line in Commonwealth v. Safarian by Justice Kaplan, which always kind of sticks in my mind. And I'm not going to get it exact, but he said something like, appellate courts are not impressed by a checklist of things that, could have been done, because that in and of itself is not evidence that a lawyer didn't get the job done. So it's difficult for us on appeal without any affidavit from the lawyer or any documentation that might suggest there was an error by counsel as opposed to a strategic decision. And it just sounds like, from my review of the brief, it sounds like it's more of that checklist argument that, well, counsel could have done this and counsel could have done that, and that's all true, and I agree with you. But that in and of itself is not ineffective assistance of counsel, that checklist. Does that resonate with you? Does that sound familiar with the Safarian language? Okay.
Yes, that does. And I thank you for saying that. I just have a short time left, but, just bringing together all these arguments, it brings us to the 4th issue that we raised, and that is the cumulative effect of these errors these issues that we're raising, insufficient evidence, prosecutorial misconduct, as well as the ineffective assistance of counsel. What we're saying is that it creates a scenario in which the integrity of the trial is irreparably compromised. As articulated in Commonwealth v. Freeman, when multiple errors occur, even if individually they may not warrant reversal, their combined effect may create a substantial risk of the miscarriage of justice. So in conclusion, we respectfully request that the court consider these shortcomings that were presented in the prosecution's case and overturn this conviction. Thank you.
I believe I misidentified you. So did you fill out an appearance slip this morning?
I was told that I didn't need to, but I did write my name underneath. That's what I was.
You just check with the court officer so we have the correct name. And I apologize for my bench slip doesn't have your name on it.
Okay, yeah, I'll
Just some housekeeping.
Okay.
Okay, thank you.
Thank you.
Ms. Johnson.
Thank you, Your Honor, and may it please the court, my name is Melissa Johnson. I'm an assistant district attorney in Plymouth County here on behalf of the Commonwealth. Just briefly, in terms of the required finding argument, Commonwealth versus Castillo tells us that we look at the totality of the circumstances to determine whether particular assault and battery is actually indecent. And in this case, just to review very briefly, we have a passenger here who was told where to sit in the car so that the defendant could see her. And after that, the conversation, which started off fairly innocuous, turned into something that could be described as suggestive. certainly by the victim, in terms of asking whether she was married or had a boyfriend, talking about bananas, and then it went on from there where the defendant actually reached back and started massaging her legs slowly from the ankle on up to her thigh, at what point he started circling her thigh and asked her if he could continue. And I think what's even more critical here is this is all being done while this victim is in the back seat of a car, essentially trapped, while the defendant is driving. And so there's certainly enough viewed in the light most favorable to the Commonwealth that this particular conduct was indecent rather than just simply an assault and battery.
Does it matter where on the thigh the touching occurred?
It does not, Your Honor. I think that the cases, including Mosby, Levine, and especially Rosa, are pretty clear that, yes, there is a list that Mosby had down of certain body parts that one can say, I wouldn't say assume, but that could lead to a conclusion of indecency. It doesn't have to be one of those enumerated body parts, although a thigh is on that list. It's really what is the context, what is the totality of the circumstances in terms of the conduct. So there isn't a particular body part here, and it doesn't matter what part of the thigh is. What the jury is really entitled to look at is the totality of the circumstances here.
I noticed that in the Commonwealth's closing argument, it referred to the defendant touching the victim on her inner thigh.
Yes.
Is there any evidence to support that?
Your Honor, unfortunately, the testimony is really the thigh. I suppose the jury could infer by him circling his fingers, which was part of the testimony, that it reached some part of the inner or outer thigh. But there wasn't any direct testimony. I believe, if I can only speculate, that the prosecutor was probably thinking of the police report or something. But in the end of the day, I don't think it matters, even if that was some sort of misstatement. It's going to be what the jury's memory that controls, and they're instructed on that. And indeed, you really look at the entirety of the context, whether it's the top of the thigh, inside, outside. Again, it doesn't matter what part of the body. The jury's going to be looking at the entire totality. It could be a body part that is traditionally not sexual, such as a mouth, or another part of the body. That there have been cases where, such as Rosa and Castillo, where there have been parts of the body that are not on that enumerated Mosby list. So again, it's the context here, and this is a case where the defendant is slowly massaging her leg as he's driving her. She's in the back and reaching up to her thigh, all after this suggestive conversation. And so the jury was entitled to, at this point, to consider, and really the jury's in the best position to consider whether, in their common experience, whether this is improper, whether the contemporary moral values, which is, I think, how the instruction is, whether that comports with proper conduct.
What about your sister's point about, in the closing, that the comment about the victim not having a motive to lie, and that victims in these type of situations often freeze? How was that proper?
So I think that the first part of your question about the victim not having a motive to lie, that was entirely proper, Your Honor. I think the cases support that. The ones that I cited in my brief, Hellberg and Smith, entirely support that. And the prosecutor was entitled to argue that in terms of the fact that this is a complete stranger. This is unlike some of the other indecent A and B cases that we have where it's a family member and there may be issues there. Not that that's what the prosecutor argued, but he was arguing, look, this is a complete stranger. Where is the motive to lie? How does she have a motive to lie here? She has no bias against this person who she essentially just met that evening.
Did defense counsel attack her as untruthful, or, I mean, did he attack her credibility as opposed to her memory or ability to perceive?
He did, Your Honor. I do believe, and I can try to answer both questions at the same time. In his cross-examination of this, and also in closing argument, he really harped on the fact that she didn't call 911. She didn't try to resist. So there was some kind of impugning of her credibility. And in terms of the final closing argument, sometimes people just freeze in these situations. I think that was an invitation for the prosecutor to say, like, look at your common experience. You know, this is a woman who is in the back of a car. She's being driven by the defendant, a Lyft driver. And as she testified, she froze. She panicked. She didn't know what to do. Should she call someone? Should she text someone? She literally froze. And so I think what the prosecutor was trying to do there is invite the jury to use their own common experience in terms of these situations. The victim doesn't just immediately open the door and jump out on Route 24. They have to figure out what to do in that situation where they're essentially trapped. Does that answer your question?
What about the certainty of the prosecutor's argument regarding the certainty of the identification?
Your Honor, I do believe that that was proper. As I cited in my brief, the case of Collins, and that was the appeals court Collins, not the SJC Collins. In terms of the certainty of identification, I do believe we are entitled to argue, unless there's an equivocal identification, which...
She said, but she was equivocal to the extent that she said she was pretty sure it was him.
I respectfully, Your Honor, I disagree with that. When we're talking about an equivocal identification, Collins really defines that as where a victim, or I'm sorry, an eyewitness, is trying to decide between two people within the array. And that's really what we're talking about, equivocal. And that, of course, is in the context of whether they get that Collins in-court ID.
But there was no in-court ID here. Is there any requirement that the ID have been, out-of-court ID have been unequivocal?
No, I was just saying in the context of whether this prosecutor could have argued that that ID was certain. And I think the prosecutor really was entitled to argue that, look, this eyewitness, this victim, identified this defendant and no other, which is really the definition of certainty, and no other, and also pointed out the fact that, look, the way that this procedure was conducted was entirely proper. We have a blind presenter, an officer who had no idea what this investigation was about. There were a number of fillers here, so there were, I think, 8 photographs altogether, and also the fact that I can't remember if it was a detective or an officer, I think it was Detective Percival, had actually advised the witness, look, the perpetrator may not be in this photo array, and yet she identified someone anyway. And I think the prosecutor was entitled to argue on the basis of the evidence, because then the judge did a fulsome ID instruction. I think he did 2 ID instructions, one in the beginning and one in the end, about how the jury can evaluate that identification. And part of that is, you know, was this eyewitness given advisements? And also, how certain was her identification? So the jury heard and knew what she said. I'm pretty sure this is the guy. They could evaluate that in terms of the accuracy. But I do think that the prosecutor was entitled to argue that certainty in addition to all the other things about that identification procedure that led to an accurate identification.
Defense counsel didn't address in his cross-examination the victim's ability or lack of ability to see the driver clearly.
Right. But the defense counsel did address it in their closing.
Right.
Yes.
But would it have been better to address it in cross-examination?
That's tricky, Your Honor, because I think if he doesn't know what she's going to say, and I think she was actually with this defendant on the ride up, so that's about a half an hour, and on the ride back, another half an hour, so she's with him for a fair amount of time.
Although on the ride up, she's sitting directly behind him.
That's true. That's true. She also was looking probably at his picture on the phone when she actually secured the Lyft ride. So I do think she had plenty of time to kind of...
Is that in the record?
No, but that could have come out in cross-examination. So there's a lot that could have come out in cross-examination that could have actually done more damage to the defendant. She could have said, look, I took a good look at his face, and then when he was turning around, massaging my leg and all that, I got another good look at his face. So I think a lot worse would have come out if he had pushed that with the victim. And then he ended up arguing it anyway in closing, even though maybe there wasn't really evidence to support it, except for just the seating position of the two of them. So in the end, I think he was probably better off not pushing that envelope.
So you're saying it was a strategic decision?
It could have been, but again, we don't have the record for that. All I can tell you is that on this record, I think the defense attorney, I should say, was able to exclude an in-court identification, which frankly is huge. They were able to cross that victim on the fact that she didn't resist and didn't call 911, which I think is a vulnerable part of this particular victim. And they were able to try to poke holes in the identification a little bit, but this is a solid case. We have enough here in this record to know that the detective had comported with all of the Silva-Santiago protocols here for this identification, and sometimes we just have a solid case, and there's not much you can do about it. If there are any further questions, I'd be happy to answer them.
Seeing none, thank you.
If
Thank
not,
you both.
Thank you.
Our next case is 23P 1321 Commonwealth versus Streed. Mr. Keneally.
Morning, Your Honors. May it please the Court, my name is Joseph Keneally, and I represent Mr. Streed. The issue in this case involves whether or not the government's interests in the imposition of GPS surveillance on Mr. Streed outweighed the intrusion on his privacy, his constitutional right to privacy. As the Court's aware, Mr. Streed in 2007 was convicted of very serious crimes. He was also given what the Court and the Commonwealth at that time determined to be the maximum sentence by law. He served the entire sentence and finished.
Well, he could have got on and after time.
Yeah.
Pardon me?
He could have got on and after time,
For
right?
sure. I mean, he could have gotten consecutive sentences, I understand that. He did get a 10-year probation sentence, and he has been out for 2 years now without any incidents. However, he has been designated a level 2 sex offender, and he does have a history of probation violations and restraining order violations.
By four different women.
Yes. However, we're talking more than 20 years ago, and obviously part of that is because he, in fact, has been incarcerated for that amount of time.
Right. So but at the time of the hearing, he'd only been out 8 months, right?
He'd been out 8 months. Yes. 2 years now. However, the notion that he didn't. That his incarceration was the only thing that prevented him from engaging in acts of aggression towards or hostility towards women is not exactly true, because there are numerous cases where that could happen within the confines of incarceration and detention. He could have done any number of things.
So the fact that he didn't assault a female guard weighs in his favor?
Well, no. I mean, when we're talking about whether or not, the court has to look at where he is now at the time of his release, and they do take into consideration whether, in fact, he has shown that he has changed the way that he's lived, whether he's been sober, whether he's been what his record has been during incarceration. These are things that the court considers in determining whether or not. He needs to be surveilled through GPS sentencing. Like I said, he does have this record.
So the SORB classifies him as a level 2.
Yes.
The Roderick case says the judge may rely on the SORB for determining level of risk. Doesn't have to reinvent the wheel. Here, the judge says high risk, even though the SORB has said moderate risk. Is the judge's finding clearly erroneous?
I think that it may be, because when the sex offender registry board looks at the circumstances, what they're looking at is the level of treatment that he's undergone. In this case, Mr. Streed completed sex offender treatment. They look at his circumstances now. They look at any therapeutic or diagnostic analyses that were undertaken during the course of his 18 years of incarceration. Whereas in this case, when the judge determined that he was a high risk, he cited the sentencing judge's determination that Mr. Streed was a very dangerous man, which in 2007 was true. He's now 18 years removed from that characterization by the trial judge. And, you know, the passage of time has been unequivocally connected with the lowering of the risk of reoffending. So I do think that to some extent, the judge's determination that he was a high risk to reoffend does contradict the SORB's determination that he's a moderate risk.
Right, but my question is, does that make it clearly erroneous? And when I asked you the question, you said, well, it may be clearly erroneous. It's got to be clearly erroneous.
Well, ultimately, I'm not sure it matters in this case, because, you know, he does have a record here, and there are circumstances that suggest that the Commonwealth has an interest in crafting probation conditions that will protect the public and protect the victim. However, in this case, it's not enough, because this is a constitutional issue. It's not enough simply to be able to cite an interest. The court in Roderick says that in order to justify GPS as a condition of probation, it's not enough to show that you have an interest, but you have to show that GPS surveillance will actually further the probationary interest. In other words, you don't just show that you have an interest in protecting the victim from the defendant. You have to show how this device and all its intrusiveness and all its invasion of privacy will actually get the job done to the extent that it outweighs the invasion of the defendant's right to privacy. And I submit in this case, that's not what happens here. Okay. For example, the Commonwealth at both the Feliz hearing and at the on appeal has devoted a lot of its argument to the notion that GPS surveillance in this case will serve the government's interest in protecting the victim. However, the courts, Feliz and Roderick, have been unequivocal that absent the establishment of an exclusion zone, GPS in fact cannot serve the interest of protecting the victim. And in this case, exclusion zones were not...
They don't say that GPS can't serve the larger interest of protecting the public.
No, they don't. They don't. I'm just talking, at this point, I'm just talking strictly about the interest in protecting the victim. They say absolutely, and the quote here is from 692, Feliz 692 at note 5. Only where GPS monitoring furthers the government's interest, only where the GPS device is configured effectively to notify authorities should a defendant enter a prohibited area. Now, in that context, they are talking about protecting the victim, not the public in general.
You say that without an exclusion zone, GPS is unconstitutional?
In general?
Yeah.
No, I'm not. I mean, there are certainly circumstances where GPS surveillance can result in direct evidence that would lead to a violation of an individual's probation. For example, in Garcia versus Commonwealth, the defendant was on house arrest pending trial. So if she left the house, an alert would go off, and as a result of the alert going off, she would be arrested for violating her probation. There are circumstances where individuals, because of the nature of their offending, are prohibited from certain areas.
Right, but my question is an exclusion zone necessary? And, you know, the fact that they should be prohibited from certain areas implies it.
Well, it also depends on the nature of the offending, too, I would submit. If the offense was something like somebody stole a car or robbed a grocery store, and you were to look and find out that the defendant at that time was at the grocery store or was right where the car was, and then the GPS showed that he rapidly accelerated away or something along those lines, and certainly GPS could serve the interest in post-investigation. But I submit that that is not this case, because the nature of Mr. Streed's offending and the kind of offending that, that the government had an interest in attempting to address was not the type that would lend itself to GPS as a deterrent for investigation purposes or even to protect the public in general.
But can't GPS serve another government interest in the rehabilitation of the defendant? So in other words, when a judge imposes a sentence and he opts or she opts not to make it as any longer and thinks about it and says, well, you know, I think he's got to reintegrate into society. We've got to kind of ease him back in, but I do have some reservations. I think probation is appropriate. Standard conditions, we'll add some other conditions. And the GPS would be good to assure compliance, especially in a case like this where if there's a history of probation violations, if there's a history of defying court orders, then can't GPS serve a purpose to sort of enable the defendant to demonstrate to the court that he's capable of obeying the orders of the court? So, for example, if there's a standard condition that says you cannot travel outside of the Commonwealth without permission of probation, can't GPS help to facilitate that so that probation can monitor, is he remaining within Massachusetts? Or do we just throw our hands up and say, well, maybe we'll catch him, maybe we won't monitor him, he could be in California for all we know. So isn't there another, in other words, it's not just limited to public safety. Isn't there a rehabilitation element here that's also served by GPS?
Yes, there are a lot of parts to that question, Your Honor. First, I would suggest that the courts have recognized that oftentimes a probationary condition serves separate interests and contrary interests. And that includes the notion that rehabilitation is often in conflict with deterrence and investigation and protecting the public. For example, one might think that, you know, we know where he is, so he might be on the straight and narrow, and that'll help him change his life for purposes of rehabilitation. But you have to remember, this is a device that's tethered to his leg permanently. Everyone knows who sees it knows he's an offender. It implicates people's ability to participate normally in social activities, whether they're personal or whether they're within the public. It has to be charged for 2 hours a day. You cannot charge it while you're sleeping because it doesn't go off.
I guess this goes back to what we said at the beginning when you said he got the maximum sentence. It seems to me that he has a lesser expectation of privacy of having been convicted of this brutal rape that occurred over 12 hours. And the judge could have easily given him a consecutive 10-year sentence for the kidnapping and the armed assault or whatever and the threats. And then he wouldn't have to worry about his function in society or looking for a job or being outside the home. He would be in prison.
That's true.
And so I'm having trouble reconciling
well, I would submit that
his interests.
I would submit that goes to the notion of the imposition of GPS for purposes of further punishment, which the SJC has said that is a de minimis interest and is probably the least important interest that's to be served. Probation is supposed to be issued as an act of grace in order to give a person an opportunity. And if the court wanted to,
parole or commutations are acts of grace. Probation is a system that's set up to not only monitor and encourage rehabilitation and reintegration in society in a lawful manner. And being tracked on GPS would enable the authorities, probation department, to make sure that he's on the straight and narrow.
Well, respectfully, Your Honor, if Mr. Streed got involved in a relationship with somebody and it began to unravel and an argument ensued and some sort of physical altercation took place, there would be no GPS alert. If he were following an individual around,
but you fail to realize that the GPS tracks his location in real time and they, like a DVR, the probation can rewind and find out where he was, which may very well corroborate your putative 209A victim that you're talking about.
That's true, but in that case...
And him knowing that would serve not only a rehabilitative function, but a deterrence function, that he not abuse yet a fifth woman.
Well, when it comes to the information that would lead to a 209A restraining order, it would necessarily have to come from an individual who says that this man's following me. And in that case, GPS data independently would not prove anything. All it would do is corroborate a report that he was acting in a certain way. So
I think that would be important evidence.
not necessarily, because, I mean, the issue is not where he was when something happened, but what exactly was that happened.
If he's alleged to be stalking her and the GPS corroborates the fact that he's in all of her locations over the past X amount of days, that would be powerful evidence against him.
Well, it would certainly be evidence, for sure. And if she says he's stalking me over a number of days, there would be nothing more powerful than the actual...
Or if he's breaking into homes, say, and the GPS, like in Commonwealth versus Johnson, puts him inside the home, accurate within 1 yard.
Well, we also have to talk about whether or not the imposition of GPS has to be narrowly tailored. And
well, I'm sorry to interrupt yet again, but in light of the Rodriguez, the SJC decided on the 1st of October, if we don't agree with your overall argument that he can't be on GPS, do you think we need to remand this to have the judge create exclusion zones with a proper scope? That would certainly make it more narrowly tailored.
No, I don't think that would necessarily even be permissible. I mean, the government had an opportunity to establish exclusion zones. They opted not to do so.
Have you read Rodriguez?
Yes.
Because that's exactly what they sent it back.
Well, I don't believe that would be appropriate in this case, because what exclusion zones would even be set up in these circumstances?
That would be up to the motion judge at a
Well, I know,
hearing.
but I mean, in this case, there's no victim here in Massachusetts that could be protected, and there's no particular.
I mean, there's interstate transfers of probation all the time.
Well, I mean, if we're talking about an exclusion zone around the victim's home in New Hampshire, that's something I have not heard of happening.
And one last thing, unless my colleagues have questions. You've included evidence of his trip to New Hampshire that
Yes.
occurred after this hearing, and the Commonwealth has moved to strike, and the Commonwealth makes a very interesting argument how this cuts both ways. And I'm wondering if you still want us to consider the New Hampshire evidence.
Well, the only purpose for the New Hampshire evidence would have been to indicate that, in fact, he was allowed to enter the state, despite the fact that the government's principal argument was, in fact, that they needed to do everything they could to keep him out of the state and to keep him away from the victim. Above and beyond that, I think it's relevant for that purpose.
Okay. Do you have anything?
Any further questions?
All right.
Thank you.
Ms. Cohen.
Good morning. May it please the court, Jennifer Cohen for the Commonwealth. Before I begin, I was planning on raising Rodriguez for your honors, as obviously it came out after we briefed this case, but I'm happy to write a 16L letter if that's
Well, no need now, but one of you should have written one.
I believe this case is comparable and distinguishable from Rodriguez. So I would say, first of all, that this was clearly a very serious case. The defendant was indicted on, had 9 indictments that he was facing, and he was convicted on all 9. The sentencing judge credited the prosecutor's characterization of the case as reminiscent of a horror movie, and independently said that this defendant could have ended up being a murderer but for the victim's reaction. And he also cited that the defendant has significant anger and dangerous impulses towards women. This defendant was classified as a level 2 sex offender. And I would argue that he is a proven recidivist, although his record does date to prior to his incarceration on these charges. He does have 4 different restraining orders against him with 4 different women. He's also been convicted on 4 occasions of restraining order violation, and he's been convicted of stalking or harassing in violation of a restraining order. In addition to that, this victim did appear at the hearing on the defendant's motion to remove his GPS, and she told the court that she was still in fear of the defendant. She chose not to tell her address to the court at that time, and the motion judge properly acknowledged that that wasn't something that she had to do. And I would say it was also very relevant that she said herself that she was doing what she could to keep herself safe. She'd gotten a restraining order, but that's just a piece of paper. And I think
Finish your sentence, then I have a question, sorry.
It's all right, Your Honor.
I didn't mean to raise my hand so you could call on me. Well, what are we supposed to do with the fact that the SORB said he was a level 2? And the judge, without explanation that I could see, says, no, he's high risk.
I think that
Should the judge at least give some explanation or point to some additional evidence that he thinks the SORB might have weighed too lightly? Or
I think his characterization of the recidivism risk here as high was appropriate. I think that at least the final outcome, that the GPS is necessary, even if the court finds that calling his risk high was perhaps an over-exaggeration, which I don't believe it was in this case. I think the GPS was still necessary, and that's based on Rodriguez, and I would say even Roderick to some extent, where the defendants were convicted of extremely serious crimes, and they were classified as level 2 sex offenders. So I think high was appropriate, but even if it wasn't, I think that really doesn't change the calculus here.
another question, can a GPS exclusion zone be set up in another state?
I'm unsure of that, Your Honor. But I would say that the GPS zone in this case, which I think acts as more of an inclusion zone than an exclusion zone, was appropriately tailored.
Is there a zone? I mean, does an alarm go off if he leaves the Commonwealth?
The zone is the borders of Massachusetts.
Where is that in the record?
I think the motion judge says that the GPS zone in a paragraph. I apologize. I'm fairly certain that he creates the zone as the borders of Massachusetts.
All right.
I think
that would be interesting to know because, I mean, you said this order had been tailored, and I don't really see any tailoring. So,
well, I think first off, where the victim does reside outside of Massachusetts, and where she was not inclined to provide her address, creating the borders, the exclusion zone as the borders of Massachusetts made sense because it wasn't any more onerous a condition than was already placed on the defendant where he's already required to stay.
Well, I mean, yes, it's a general condition that he can't leave the Commonwealth without permission, but wearing a GPS bracelet around is certainly more onerous than merely having to apply
Sure.
to leave the Commonwealth.
But I would argue in this case, and I would compare this case to Rodriguez in the fact that the court found that the GPS was certainly warranted, and I think in this case
In Rodriguez, there are exclusion zones to be established.
In Rodriguez, they established the zones as Framingham and Marlborough, which was a banishment.
Too broad, so the court sent it back. But
correct.
In anticipation of narrower zones being established, plus that he was a level 2 and it was a serious crime.
I suppose, Your Honor, in the event that the court disagrees with me and finds that the zone was not appropriately tailored, I think that, again, this case should follow Rodriguez and be sent back to the court to determine whether or not a GPS zone can be established around the victim's home at the very least. I think that would be something that could be done here. But again, I do think where in Rodriguez there was a banishment, and while I have asked the court to strike the allowance of the defendant's motions to travel, I think, especially in light of Rodriguez, those documents are helpful to the Commonwealth because it shows that this defendant was not excluded from everywhere other than the Commonwealth. When he came to court to ask for permission to travel. This was granted. It was granted for particular dates under particular circumstances, and I think that goes to the rehabilitative purpose of probation. And I would say that, again, I'm not saying that the GPS itself isn't onerous, but where he already is required to stay in the state and he's already required to go back to court to get permission to leave the state, the exclusion zone itself is not onerous to him as it was in Rodriguez, where the defendant was banished from a large geographic area.
So Roderick says that the intrusion upon the defendant's privacy is aggravated by the fact that he was ordered to wear the GPS bracelet for 3 years. Here we have 10 years.
Yes.
And the judge said, yes, you can come back after 5.
5.
But Roderick says that's inconsequential because whether the judge says that or not, you
Right.
always seek to modify it.
And I do think that's probably, the Commonwealth's least persuasive argument on this decision, because I think if there was a great change in circumstances, obviously the defendant could go back to court to move again. But I do think
Do you
where...
agree that we should look at this as if it's 10 years?
I think we should look at it, well, I think the court
Pretty
should
long
still look
time.
at it as 5 years, but I think that which was what was ordered by the motion judge.
10 years was ordered, and he refused to vacate it. He said you can come back after
Correct.
5, but defendant could have done that anyway. So don't we have
Sure.
to look in terms of the onerousness at wearing this for 10 years?
Sure. Well, and then in that case, if the court looks at it that way, I understand. But I do think, again, the facts of this case are extremely serious. This is not a situation...
10 years,
Sure.
no exclusion zone.
Well, there is an exclusion zone of remain inside Massachusetts. I believe the judge sets that zone when he acknowledges that the victim is not providing her address to the court. It's in the same paragraph. He says...
That's in the transcript?
In the motion hearing transcript.
But that doesn't mean probation doesn't know. It just didn't come out at the hearing.
Correct.
What I'm a little puzzled by is the standard of review. You'd agree it's de novo?
Yes.
And it's de novo, as I read the cases, because it's a constitutional issue, and yet we apply other standards of review to constitutional issues all the time. So that puzzles me. But the other thing that puzzles me is we rely heavily on trial judges to make decisions, fact-bound decisions, assessing credibility of witnesses and so forth, and making judgments as far as sentencing that they are very well suited to do and we are not. And yet it seems like now we're going to have a three-headed judge basically take it upon itself to make a decision de novo without hearing any evidence. And apparently, are we to ignore the findings of the judge in this case and ignore the judge's conclusions? Because in the transcript, he seemed to take great care to put on the record why he was taking the action he took. Are we supposed to ignore that entirely?
I don't think that you do, Your Honor. I think that you...
But it's de novo, though.
It is de novo, but I think it is de novo with the caveat that the court accept the subsidiary findings of the trial judge or motion judge, and especially those judges that heard oral testimony. So there is perhaps a combination there. But I think that's why the words of the original sentencing judge are so important. I think that even though there is a de novo review where you can look to those words, and I think that's just it's very important. If there are no further questions, I will rest on.
No, thank you. Thank you both.
Thank you.
We're going to take a short break.
All rise.
Our next case is 24P294, Chelmsford Crane Services versus DBA Welding. Mr. Nicosia, did I say it right?
Yes. May it please the court, good morning, Your Honors. Attorney Peter Nicosia on behalf of the appellant, Chelmsford Crane. I did see the docket entry that was made about the jurisdictional issue, so why don't we talk about that first.
Thank you.
I did review the Aliberti decision at great length. I realized that both Justice Meade and Justice Sachs were authors of that decision, so I understand why the issue was raised.
You were on the panel. Justice Massing authored it.
I think our situation is distinguishable here for the following reason. It seemed to me that the primary motivation for the decision in Aliberti was the fact that after summary judgment was granted and that remaining undue influence claim was left over, the parties then dismissed that claim without prejudice. And the court reasoned in that decision that, you know, the threat of that litigation coming back would subject the court to multiple appeals. That's not the case here. The joint stipulation for final judgment, as it was crafted by both counsel for both parties and endorsed by Justice Hagan, in paragraph 5, we specifically deal with that issue that if this appeal is not successful, such that, you know, the case isn't going to be remanded back down for a trial proceeding, that remaining portion of Claim 2 is dismissed with prejudice.
But if it is successful?
Yeah, that's paragraph 4.
Or 5, I thought it was 5.
No, you're talking about 5. We're talking about paragraph 4.
So, so if this appeal is successful, then the summary judgment decision is going to be overturned, and then the entire case is going to go back to the trial court for a trial on the merits, which would include the remaining portion of count 2.
But the trial on the merits could result in a defense verdict on everything but the claim that you've set aside, and then there would be a second appeal just on that.
The only way that there would potentially be a second appeal is if there was a trial on a reverse summary judgment decision which would encapsulate those claims that have been dismissed plus the remaining claim on count 2. So that would be after a full trial on the merits.
Right, but then if the trial on the merits results in a defense verdict on everything except count 2, and then you prevail on count 2, then the defendants appeal. So then we've got a second appeal in the same case.
But aren't you facing that situation regardless? If the summary judgment is overturned and sent back to the court for a full trial on the merits, and there's a plaintiff's verdict in that case, isn't the court subject to an appeal from the defendant potentially?
Have you not tucked away some claims that are going to be tried in this case?
I'm indicating that the one remaining count that's out there is the remaining portion of count 2, which is the unjust enrichment and quantum merit claim.
There's no breach of contract claim too?
Well, that's a separate issue with the bankrupt defendant that we have. So that's a separate issue. We viewed this joint stipulation of judgment as a separate and final judgment. And
Yeah, I know you did, but that might be the problem. I mean, what you should have done is got a 54B separate, or asked the judge to report it on a Rule 64, and you didn't do that either.
I think that was the intent behind the discussion and the sign-off, because in the stipulation of judgment, it indicates at the end of it that it's a final judgment. So that was the intent behind filing that stipulation, was to make it a separate and final judgment.
But if there are things that remain to be done back in the trial court, then you needed a separate and final judgment under 54B to come here.
We viewed that joint stipulation of judgment as it was filed as that purpose. I know there isn't an express finding by the trial judge.
I know what you intended to do.
Yep.
But unless you actually dismissed everything that agreed to dismiss everything except for the things that you're appealing here, then you need a 54B.
We viewed that, and I believe Justice Hagan viewed that stipulation of final judgment as a separate and final judgment.
Well, usually when a judge enters the 54B, the judge gives some reasoning as to why it makes sense to have certain claims appeal while others are pending.
Well-
And then we could review that.
In this case, I believe it was because of the bankruptcy and the likely discharge that's probably forthcoming for DBA Welding. That case is technically, the bankruptcy docket, I looked at it yesterday, it's still pending.
Right. Well, but that wouldn't explain, I mean, that might be a good reason to have a 54B, but that doesn't explain the reservation of count 2.
Well, I think the purpose behind it was that if this appeal was not successful, then that would be dismissed with prejudice, as opposed to reserving it for another day. And
But
that
the
was
judge
not,
would
that
also-
didn't exist in Aliberti.
Right. But the judge would also have to consider whether, if this appeal were successful, and then there were a trial, and then we go through the scenario we went through before, there would be a second appeal, and whether it makes sense to delay all of that pending the outcome of this appeal, or whether it should just go ahead to trial on count 2, and depending on the results there, either party or both parties could appeal.
I know the transcript of the hearing that we had on the entry of that joint stipulation is not part of this record appeal. That was the analysis, basically, that took place, that the most economic way to meter out the rest of this case is by the way that we did it, rather than having a singular trial on the remaining portion of count 2, which effectively was, depending upon how you value the case, a $5,000 to $15,000 damage claim.
We may have different ideas of economy. It may be economic for you, but there's judicial economy at stake as well.
I understand that, but I do think that Justice Hagan was analyzing that in terms of having a full-blown trial on the merits of such a narrow claim without having the larger claims that were dismissed on summary judgment addressed first.
Other than the fact that this appeal is pending, is there anything preventing you from going back and asking for a 54B or a report of the summary judgment decision?
No. I mean, I guess I would ask the rhetorical question, if that were to take place, I would assume the appeal would remain pending, pending receipt of a further trial court order.
We're not going to reach agreement on that. Why don't you go ahead to the merits in your remaining time?
Okay. I'll touch upon them briefly. I know they're pretty fact-sensitive. So I'm going to do them in the inverse. For the very reason why Justice Ritter didn't dispose of the post-March 5th, 2020 work claims is the reason why I feel that the mechanics lien claim should not have also been dismissed as it relates to those claims, as well as the 93A claim. So with respect to the reservation of the remaining portion of count 2, basically what the court found was that, at least for the limited amount of work from March 5th, 2020 on, Chelmsford Crane was effectively a first-tier subcontractor to United Steel.
You say effectively, and they say that you're a subcontractor.
That was the basis for dismissal of everything pre-March 5th. But Justice Ritter in his decision points out the fact that all of the work slips which had been signed off by DBA Welding pre-March 5th, we have the March 6, 2020 work slip, which is signed off by United Steel. So in that case, you have a document which is satisfactory of the statute of frauds to assert a claim for a mechanics lien, at least for the March 5th work and beyond.
Right, but that's count 2. That's why it might not make sense to have this appeal decided aside from count 2.
I understand the jurisdictional issues you're raising. I'm just speaking to the merits of the 254
right, no, but on
claim
the merits,
right now.
the fact that some work was done assertedly at the direct request of United on March 6th is a fact that might support count 2, but how does it support the others? I mean, as to the other prior invoices, wasn't your client, Chelmsford Crane, a subcontractor?
So the argument is that we're a third-tier subcontractor on pre-March 5th work, but for the same reason count 2 survived for March 5th and beyond, then the 254 claim should have survived for March 5th, 2020 and beyond. It's the same analysis. And it's one step further. We do actually have a writing signed by the defendant to satisfy the statute of frauds. So it's the same analysis in my view.
Is that, and you're saying that created a contract?
Yes. Yes, and the case law that has developed over the past 5 years or so don't speak in terms of a fully integrated contract to assert a mechanics lien claim. You just need a writing sufficient to satisfy the statute of frauds, and that slip does it. So, again, for the same reason that we survived on count 2, we should survive for the mechanics lien to enforce collection of count 2. Similarly, on the 93A claim, because the court basically reasoned that the 93A claim is just purely derivative of these other claims for the contract and the quantum merit and the unjust enrichment. However, they made no independent finding on the unfair and deceptive nature of the conduct of United Steel inducing my client to finish the work, asking my client to do work outside the original DBA scope of contract by placing those stairs after March 5th.
And that was by saying you're going to get a joint check.
Yeah, we're going to get a joint check, and then on top of that...
Did they say when you were going to get the check?
We believed it was, so after we completed our work, we believed it was going to be immediately. So there was additional charges to be incurred, which United Steel had agreed to pay for the placement of these stairs after March 5th, which they also didn't pay. So they induced us with a joint check for past payment. They induced us to expand the scope of work with additional direct payment from United Steel, and we still never got paid. So those facts, standing alone, create a factual dispute where, at least for post-March 5th, the 93A claim should have been viewed as a factual dispute and should have survived. The longer-range arguments, of which the primary basis of the summary judgment was decided on, was this reasonable expectation of direct payment from United Steel. The universe of the fact record, there was a cluster of emails and phone calls and things of that nature, which were all recited in the appendix and in the...
Was anything done in reliance on those assurances? Those all seem to be fairly late in the sequence of events here, after Chelmsford Crane had done all the work except perhaps the March 6th work.
So, fair question. I think that the emails seem to date themselves around that time period, but you have Mr. Ferretra in his affidavit and his deposition transcript talking about earlier oral representations that were made to him by other parties, including United Steel, about assurances that if DBA is not going to pay, that he would be paid. And beyond that, they did make additional representations in these emails about the joint check and about future payment for the extra scope of work. So I think that's enough to at least create a factual dispute. Now, the only thing that exists in opposition to that in the record from Mr. Ferretra's testimony is the affidavit of Mr. Corneau, who's the president of United Steel, basically saying that, they made no such representations. But that's sufficient for a factual dispute to have survived summary judgment, in my view. A jury should have been able to hear Mr. Ferretra's testimony about the phone calls and the in-person representations that were made as to whether or not the timing of those and whether or not that led to additional inducement and reliance to complete the remainder of the work. The other point I want to make is Justice Ritter made no findings whatsoever about the measurable benefit that my client conferred here. My client was the crane rental guy. He rented the crane to them. He gave them crane operator time. The fact record is devoid of any allegations of improper work or negligent work in terms of just pure rental of the crane or an operation of the crane. The arguments that have been raised by Mr. Corneau in his affidavit are unsupported by any independent facts, and they're all directed at DBA Welding's conduct. None of it has anything to do with Chelmsford Crane services of just providing the crane equipment and the man hours to operate the crane. So there were factual disputes as to whether or not my client performed the measurable benefit on the site, and there was no findings whatsoever. The judge purely focused on the reasonable expectation of direct payment and sidestepped.
What was the benefit that United Steel got?
$168,000 worth of crane rental time and crane operator time, of which we were paid, I believe, $30,000 or $20,000. I can't remember the exact figure. So they got all of that to erect the metal structure of this building, and At the end, when they realized that my client had not been paid by DBA Welding yet, there was $130,000 left, of which they earmarked that for my client, and we're going to make it a joint check, which effectively would have come close to zeroing out my client's balance at that point. And that, to date, has still never been paid. We still have never been paid for the extra work, and the offsets that they're claiming are DBA's conduct and has nothing to do with us. So,
Okay, thank you.
thank you for your time, Justices.
Mr. Lane.
Good morning, Your Honors. Paul Lane representing the two appellees, United Steel and its surety company, Great American. Based upon your questions, I'll focus in on a couple of the issues you've raised already. I think it's important, and it can in some ways be...
I hope you're going to start with jurisdiction. I want to hear your view.
I'm sorry, Your Honor?
I want you to start with jurisdiction, our jurisdiction.
I can't hear you, I'm sorry.
What's our jurisdiction to hear this appeal?
Your Honor, the amount of the claim remaining based upon Judge Ritter's decision was $6,695.31, and we believed, based upon the agreement that if the appeal was not successful, that those claims would be dismissed with prejudice, that satisfied the applicable standards and case law, such that there would be no more case unless this court decided to remand this action. And we spoke to the court about it. We were, I understand, judicial economy, we were trying to do right by the clients. So, like my brother, I would stand behind that stipulation and the order that it does give you jurisdiction to decide what's been appealed, and that unless this court chooses to remand the case is over. I don't understand what's left to appeal with my brother having agreed that the rest of the case is dismissed with prejudice.
I didn't see that in the stipulation.
It was framed, Your Honor. We felt in that manner that the use of the term with prejudice, I know we both conferred extensively, talked to other people. We've both been practicing for a while. We didn't feel it was a 54B certification. I'm familiar with those issues generally, but in light of the way we framed the stipulation, we felt all issues would be addressed, and unless this court chooses to remand the case is over. There could be no more appeals based upon the use of with prejudice. May I speak to the merits, Your Honor? So I appreciate the court focusing on the issues in terms of the specifics. And actually, the Chelmsford Crane is a fourth-tier contractor on this project. We have the owner of this assisted living facility in Newton. We have a general contractor. We have my client that furnished and erected the steel. They, in turn, sub some of that work out. And that subcontractor, DBA, who filed bankruptcy, in turn hired a crane rental company, because to erect steel at a 5- or 6-story building, you need a crane. The evidence is clear. We did not know anything about Chelmsford Crane, had no dealings, no knowledge of who they were, what they were doing in light of that relationship I described until a March 5th phone conversation. And my brother is mentioning the billing and the slips. If you look carefully at the record, the March 5th time and charges go to DBA Welding, as all the other bills did. That was the customer relationship. The March 6th time also goes to DBA Welding. The only thing that happened, Your Honor, was on March 6th, as we were trying to finish the work, DBA Welding left the job site. As often with union contractors, they were done at 3 o'clock. My client wanted to get one piece of work done that was supposed to be done by DBA. Our folks stayed out there, and one of our employees signed the March 6th slip, Robert Binsey, saying, verifying time and materials. Even that charge, that final day's charge, was billed to DBA Welding. That's what the paperwork supports. So the actual documentation regarding the claim all flows to DBA Welding. We have a phone call with Erland, who at one point was named the GC. They were dismissed. We have a phone call the second to last day of the project, and what the follow-up correspondence is, okay, send us your invoices, Chelmsford. We now know who you are. Let's see what you did out there, and as you're aware, right around that time, DBA defaults on the project. So I think a close look at the facts, I think Judge Ritter did the right thing. He understood there could be no quantum error claims when you don't even know who the company is. You have no relationship with them. You didn't even know enough to know they could expect to be paid by you because you didn't know who they were until March 5th. So I apologize to the extent we've created any confusion on the record, but we believed we were handling this case appropriately by saying the rest of the case goes away unless you find that the quantum error claims exist, which is the only thing I understood was left of the case, quantum error in count 2, and then the mechanics lien, Your Honor, I'll speak to that briefly. It's quite clear in the statute, 254 Section 4 says that when you're this far down as a tier contractor, essentially from an equitable viewpoint, it's not fair for the owner to have to be expecting liens from someone who is that far removed in terms of privity and relationships. So the statute is very clear on its face. You can only seek a mechanics lien if you have a contract with 1, the general contractor, or 2, a subcontractor on the project. So I don't understand in the first instance how the lien was pursued because that's pretty clear language in the statute. And beyond that, as you can see, just in case that isn't as clear as I believe it is, I argued other reasons why there's no lien.
Just to be clear, the lien is on the property?
Yes, Your Honor, the lien was asserted against Sunrise Development, so it was on that building. And of course, the next thing that happened is Erland gets notice of it and says to us, take care of that lien. We went out and paid for a bond, which is issued by Great American. So the lien was on the property, but now is no longer on the property through the bond. And if there is no lien, there is no claim against the bond. So we feel very strongly on the mechanics lien issue. I wasn't honestly even aware that was going to be appealed, but it was. And then on the quantum error arguments, you know, the brick construction case, the Fernard case, it's a very significant burden for someone in this structure of relationships to be able to say, you owe us $160,000. There's all sorts of reasons on a construction project, just because someone goes bankrupt, that you can't then say after the fact, well, gee, I want to be paid by you, or gee, this isn't fair. It wasn't fair to either of us. Our client lost a lot of money on the project. Apparently Chelmsford Crane did because there was a bankruptcy, but that does not give Chelmsford Crane the right to leap over DBA and then say, by the way, you owe us all this money. And I think that's what Judge Ritter found. We put together detailed affidavits. We put in all the invoices, all the paperwork. I think he reviewed the record clearly and felt the only claims that could possibly exist were for those 2 days. And I've explained why even those don't exist, and my brother agrees those goes away unless he is successful on the remainder of the case.
I can understand why you both didn't want the count 2 to be the tail wagging the dog. If the plaintiff does succeed on count 2, would that strengthen any of the other claims? Would that contribute to a likelihood of success on the merits of the other claims?
I don't believe so, Your Honor, because again, the focus of the decision and the trial testimony was only going to be about those 2 days worth of work. The argument being there couldn't possibly have been any other claims for the other time period.
No, but I'm saying if all of the claims were still alive, if for some reason we were to vacate the summary judgment order, then would success on count 2 contribute to a likelihood of success on any of the other counts?
I don't believe so, Your Honor. I don't.
And it's not settlable? I mean, we're not here to facilitate settlement, but, it seems like a pretty small dollar amount.
Your Honor, I certainly understand that, and I think the essence of my brother's argument was these quantum merit issues needed to be brought before you. I've cited to cases that I think are very close that say this is not a situation to give quantum merit relief. And we thought we were coming before you to address those issues, and if those are dealt with, the case is over. And we did talk to Judge Hagan and try to do this effectively for our clients and for the court.
What about the 93A claim?
We argued the expected case law, Your Honor, that if there's no quantum merit claim, that there could be no finding of any type of 93A violation. So that was sort of Roman numeral number 1. And then Roman numeral number 2 was based upon the facts in the affidavit of Mr. Ferretra and his deposition testimony. I think Judge Ritter was confident there was nothing that would raise his eyebrows or the jurors' eyebrows or judge's eyebrows as to improper conduct. Again, it's a phone call.
The promise of the joint check to
There's no promise, Your Honor. There's no evidence in the record where anybody promised a joint check. The only thing is in the record is a discussion about a possible joint check, and then an email from our project manager about 10 days later saying, okay, send us the invoices. If that was the evidentiary record, it would be, we are going to be issuing a joint check on a particular day. That's not the evidence. It was a conversation, kind of typical in the industry, to discuss, gee, you're owed money, let's take a look. And around that same time, unfortunately, DBA stopped showing up on the job. And again, we have a claim in the bankruptcy estate too, which we don't think should have any effect on this appeal. Whatever happens in the bankruptcy court happens. So we feel that obviously the judge understood all those issues, dealt with it in terms of the relationships of the parties, and made the appropriate decision.
No, all right. Thank you. Thank you both.
Thank you, Your Honor.
Our next case is 24P420, Mount Auburn Hospital versus Commerce Insurance Company. Mr. Ty.
May it please the Court. Good morning, Your Honors. My name is Daniel Ty. I represent the Commerce Insurance Company. With me at council table is my colleague, Michelle Pescucci. Your Honors, this is a contract case, and the central issue is whether the courts below applied the correct definition of a term, a particular term, covered person. The contract that Mount Auburn Hospital signed contemplated multiple contracts.
Can you explain why it matters whether Commerce is a intended third-party beneficiary of the network access agreement?
Your Honor, I think Commerce is an intended beneficiary of the Mount Auburn
PPO agreement.
PPO agreement, yes, Your Honor.
That was going to be my follow-up question, and I hope that Mount Auburn will address that. But the parties seem to disagree about whether Commerce was an intended third-party beneficiary of the network access agreement between PHS and AIS. And I'm wondering, why is that material?
I don't think it is material, Your Honor, but because the subsequent contract make Commerce a direct participant or a direct member of the PPO network. For purposes of this appeal, I think the only question is whether Commerce is a third-party beneficiary of the PPO agreement. And I would note there, Your Honor, that Mount Auburn cites a provision in the, I believe, the network access agreement that talks about third-party beneficiaries. That's not Mount Auburn's contract. In the PPO agreement, there is no disclaimer of third-party beneficiaries.
Okay. The amicus brief in some footnotes says that under the PIP, Commerce essentially can't steer patients to Mount Auburn Hospital, unlike perhaps under group health or workers' comp. Why is that? It seems to be taken for granted by the parties who are probably more familiar with how the PIP works than us.
Your Honor, my understanding of this comes from this court's decision in a case called Metropolitan versus Emerson Hospital, in which there was a very similar PPO agreement that was litigated, and in that case, the issue was whether there needed to be some sort of registration with state regulators because of this steerage question. I think that's the language they use in this industry. And this court found that there was no steerage, there was no evidence of steerage, and it didn't need to be registered with regulators, Your Honor?
There's a requirement of statute that if there's going to be any steering.
Your Honor, that's my understanding, and
it can't be done in the PIP context?
If it's done, I believe it has to meet some regulatory requirements, Your Honor, and I think all the parties are in agreement that that regulatory regime doesn't apply to this kind of arrangement as it would with a group insurance program, Your Honor. That's my understanding. And again, that comes from this court's 2021 decision called Metropolitan versus Emerson Hospital.
But is it undisputed that even though there's no steering, Mount Auburn would benefit from prompter payment with fewer administrative costs?
Your Honor, I think...
Because we're trying to understand what is the purpose of this whole chain or web of contracts.
So, Your Honor, the contract is broader than just no-fault auto. No-fault auto is a component of the PPO network, but Mount Auburn gets a lot of benefits from this contract. I'll stick for a moment with the no-fault auto.
I understand that they get access, that they're part of a PPO that serves other types of insurers. But
yes, Your Honor.
For purposes of the PIP, what's the benefit?
Well, Your Honor, the PIP statute doesn't say that Mount Auburn is entitled to recover its invoiced charges. It's entitled to recover reasonable charges. And here, Mount Auburn's entitled to, by contract, 95% of whatever it gets for an invoice. If it just submitted those under the PIP statute, carriers would have the right to say, we're going to pay you a usual customary rate for those services, which might very well not be 95%. For example, in the group health context, I believe carriers almost never get the invoiced amount. There's a negotiated rate that's quite a bit lower. So the fact that Mount Auburn is getting, this case is phrased as they're giving a 5% discount, but actually they're getting 95% of the billed amount, which is a benefit to them. And other benefits, of course, are that there's a systematic payment process in place where the bills are paid promptly, systematically, and according to negotiated protocols.
Mount Auburn says that they're not covered by the broader definition of covered. I'm sorry, the broader definition of covered person doesn't apply to them because they weren't a party to the prime AIS contract.
That is exactly their argument, Your Honor, which I'll address. It's a textual argument, Your Honor. So the PPO agreement, Your Honor, specifically contemplates subsequent agreements. So the whole idea is we're going to have this network. So the 2007 agreement that Mount Auburn signs contemplates subsequent agreements with insurance companies and perhaps also with employers. And we can tell that because throughout the contract it uses the phrase payor, P-A-Y-O-R with a capital P, to mean, among other things, insurance companies. And it talks about payor programs as the programs by which the payors decide what coverage to pay for, okay? And throughout the contract that Mount Auburn signed, I counted 11 different references to payor programs. Now, they never, ever delineate what insurance company they're talking about or what employer they're talking about or what payor program they're talking about. And that's because they're looking down the field and they're suggesting there's going to be more contracts later on. And that's why I think, Your Honors, Section 8.6 is the critical provision, both in this dispute, but also with respect to the whole program, because it evidences the fact that the parties wanted flexibility.
Is a provision like 8.6 common in these PPO agreements?
I don't know that, Your Honor. I really don't. But what I will say is that in these PPO arrangements, they very commonly involve multiple contracts. So I'm just speaking now from a common sense perspective. There has to be a way to reconcile these contracts. After all, Mount Auburn wants very much to have insurance companies join this network. They want that. And so the contract is drafted to be as flexible as possible to permit that, which is why Section 8.6 specifically says, in the event of a conflict.
I'm curious why the agreement doesn't require PHS to give Mount Auburn copies of the agreements that PHS enters, so that Mount Auburn can say, is this a good deal for us or not?
Your Honor,
I see the provision about notice of amendments, which the parties have discussed in their briefs, but I couldn't find anything requiring that Mount Auburn get a look at the terms on which others are admitted to the, given access to the PPO.
It's a good question, Your Honor, and I don't have a firm answer for you, certainly not in the record. But what I can submit to you is that that whole issue of notice wasn't litigated. That was not before the trial court. When the trial court found for Commerce, there was no evidence that Judge Byrne was looking at relating to this issue. I think that the amendment question, we addressed this in the briefs, doesn't apply because that talks about amendments to payer programs. There's no evidence that this was an amendment to the payer program. Sometimes in their brief, Mount Auburn kind of drifts a bit and they talk about amendment to the PPO agreement. That's not what this is. That's not what the provision says, and that's not what this case is about.
And the redactions too, was that raised in front of Justice Byrne?
It was not raised, Your Honor. There was no motion to strike. It wasn't raised below. And I would submit, Your Honor, that it's fairly obvious from looking at the redactions that they're commercial terms that were redacted. There are no definitions that were redacted. And certainly, Commerce has not suggested that there's anything in the redactions that relates to this appeal. But this is why you're supposed to raise things at the trial court. If there was, the time to resolve it was before Judge Byrne.
Yeah. So you cite the NSTAR versus DPU case as saying that the parties can agree to be bound by a contract that references terms to be specified sometime after execution. As I read that case, it was about exhibits that were attached to a settlement agreement. And the question was, were they incorporated by reference? They were. They existed at the time, and the court said, yes, they're incorporated. But here, this somewhat open-ended 8.6 seems to contemplate contract, at least in your view, contracts that could be executed in the future. Do you have a case that's essentially more on point than NSTAR? And if you're going to talk about Lafayette Place, which says you can have formulas and procedures for specifying future terms like price, what are the formulas and procedures that apply here?
Your Honor, I would refer to Lafayette Place because I think that that principle is what is live here. And there's also a case called Cygan, I'm probably going to mispronounce this, but CYGAN versus Megalthin, MEGALTHIN, 326 Mass 732. And Your Honor, I think what I would say to you is, as far as I know, neither of those cases dealt with future contracts, but they dealt with future events. And that's what really this contract was dealing with. There's uncertainty about exactly what a future insurance company, a future payer might want. Everyone understood and accepted that. And the remedy for Mount Auburn, if they really didn't want to participate in that, was to bow out of the network. They had the right to leave the PPO network.
That's leaving the whole PPO. That's not just saying, no, we don't want to serve that payer.
That's correct,
So
Your
that's a
Honor.
pretty steep price to pay for a disagreement, isn't it?
Well, it is, Your Honor, except that the reason that Mount Auburn is included in the network is because of their agreement to include carriers, right? So, yeah, if they don't want to give the 5% discount to Commerce or maybe a different discount to a different carrier, sure, they would have to leave. They didn't, Your Honor. And all I'm suggesting to you, Your Honor, I'm not aware of a case that's on all fours with this about future contracts, but what I'm suggesting is that it is, I think, very clear from the context of the contract that the parties saw this coming. They wanted this to happen. In fact, there are provisions in the contract that specifically say that the PPO, Prime, reserves the right to go out and find other members of the network. So that's what everybody expected to happen, and that's what did happen.
But what do you say to Mount Auburn's argument that contemplated bringing employees on board?
Your Honor, I would submit that that just doesn't make much sense. I acknowledge that the original definition of covered persons talks about employees. But if we think about the whole sort of totality of this contract, we're talking about payers, which specifically are a number of employers or insurance companies, payer programs, which are the sort of rules of the road that are set by these insurance companies or employers. To limit the definition of covered person to employees in that context doesn't make a lot of sense contextually. And so I think that's why 8.6 is so important. It's because everyone knew, well, if an insurance company comes in, they're going to redefine that term, and we're going to have to live with it because we want that insurance company's money. I see that my time is out. If Your Honors have any questions, I'd be happy to try to answer them.
No, seeing none. Thank you.
Thank you, Your Honors.
Ms. Pierce.
Good morning. Brittany Pierce for the Appellee, Mount Auburn Hospital. The issue in this case is that the individuals whose treatment is at issue are not covered persons, and therefore Commerce was not allowed to take a discount on the bills for their treatment.
So you obviously rely on the definition of covered persons that's in the PPO agreement, and they're relying on the other provisions in the network access and I think the master services agreement. But you're saying that if the contract were interpreted their way, then it would be so vague as to be unenforceable, in essence. So indeterminate, you know, it's a material and substantial critical term of.
Yeah, so I think that covered person is setting out who is entitled to the discount and under what circumstances.
Right. So this is what I want to, well, sorry, finish your sentence.
Well, so that, because that sets out who gets the discount and when, that is essential and material, because without that information, you have no contract. That's just as essential and material as the amount of the discount that is set out in the contract. I think it would be absurd to say that later parties could enter into a contract and determine that Mount Auburn suddenly has to give a 20% discount or a 50% discount because they put that in their contract. Mount Auburn is not a party to that. They never agreed to that, and we wouldn't hold Mount Auburn to that. And the same logic applies to the term covered person, who is entitled to the discount and when.
So here's my question. If this agreement's definition of covered persons had said any employee or other person who's entitled to receive covered services under payer programs, would the agreement still be definite enough to be enforceable, given that other persons still have to be those who are covered by either a group health or workers' comp or PIP?
That would be a very different circumstance, yes, and that here they.
So yes, it would be enforceable?
I
know the parties didn't.
I think that if that language is included, then the patients whose treatment is at issue here would potentially qualify as covered persons.
Well, is there any reason they wouldn't? I want to.
I don't know. I mean,
potentially, if we can.
If those were the specific words, then I mean, looking at it, likely that they would qualify. But I think the way that it's set out now, it's any employee who's entitled to receive covered services. And when you read the definitions that are contained in the different contracts, they don't conflict with each other the way that paragraph 8.
But how does 8.6 as applied here do any more than put the words "or other person" into the definition of covered persons?
Well, first, I don't think that there is a conflict in the language, because the definitions in the contracts can be...
The parties are disagreeing. You say that the person has to be an employee, and Commerce is saying, no, they don't have to be an employee. That seems like a conflict.
I understand that, but I think when you look at what 8.6 actually says, it refers to a conflict in the language, not to the way that it is interpreted. And here, Commerce is essentially asking that the term covered person be looked at individually in the different contracts.
Oh, the Master Services Agreement, for example, between Commerce and AIS defines covered person as an individual insured or a claimant under a policy. That's a conflict, because there's nothing in there that restricts it to employees.
But the purpose of the series of contracts here is that they be read together. And when you look at the contracts together, you can harmonize the definitions that are contained within the different contracts, because a Commerce employee could be injured in an accident and be entitled to receive covered services for which Commerce is responsible for payment.
What language says it has to be a Commerce employee versus an employee of AIS or PHS or anybody in the world, as long as they're employed by someone?
Well, just in the context of these contracts here, we're referring to Commerce because Commerce is the payer that's at issue, and that's part of the payer program. But it wouldn't apply to an employee of AIS either.
Why not?
Well, because the patients who are at issue here, as far as we know, were not employees of AIS or Commerce. So they wouldn't qualify as covered persons under
But they're not employees,
that definition.
But they're not employees of Commerce either.
Right, which is why they don't qualify as covered persons.
So it's a very narrow pool then, if it's just Commerce employees, right?
Well, only when looking at these three contracts. There are likely several other contracts.
If covered persons only applies to Commerce employees, what's their incentive in participating in this? I mean, if I have it wrong, but my vague understanding is that they promote the services of Mount Auburn Hospital.
Well, Mount Auburn entered into a contract with Prime.
No, I'm sorry, is that right? Is that right?
Commerce does not promote Mount Auburn, no. Mount Auburn and Prime entered into a contract where Prime is to promote Mount Auburn's services to its clients, and then Prime has the contract with AIS, and AIS has a contract with Commerce. And when Mount Auburn and Prime...
If they're only going to be able to discount an exceedingly small pool, why would they do this?
I would say that employers often have benefits for employees. There could be workers' compensation. There's several other types of clients that Prime could contract with and likely has contracted with. And when this original contract was entered into in 2007, Commerce did not even have a contract with AIS at that point, so they weren't even a consideration. They didn't enter into their contract until 2012, 5 years later, and then there still was no link between the two because the Prime and AIS contract wasn't entered into for 3 more years in 2015.
So you mentioned that this applies to other kinds of coverage besides PIP coverage. So let's assume that I'm an employee of a company and that I and my family have some kind of family coverage under the employer's group health insurance plan. And then my minor child has some need for health care and goes to Mount Auburn Hospital. Is my minor child a covered person?
Well, I don't know how the interpretation would be, to be honest, but...
Okay. Well, but it seems straightforward in your view because covered persons is defined as employees. And my child is not an employee of my employer.
But potentially, if the insurance is through an employee, then it would apply to other
By virtue
family
of Section 8.6.
No, I don't think through Section 8.6, because again, 8.6 just refers to a conflict in the language. And if I could, I would actually
Well, then,
point...
if not by virtue of 8.6, then by virtue of what language in the PPO agreement would a minor child of an employee be covered in the my hypo?
That I don't know. I honestly don't know how that would. I was just saying because if the employee is the one who has the benefits, perhaps if a minor child also carries those same benefits, they would qualify as well. And I'm guessing that would likely be...
Because maybe the group health plan defines covered person as any employee of this company and any minor child of that employee when the employee has opted for family coverage, and a spouse.
Possibly, yes. But again, so those definitions can be read together.
Well, how can they be read together?
Well,
Your PPO agreement says the covered person has to be an employee.
But then it's further defined in the later contract,
Right,
as
and
you
what rule
mentioned.
do we use to decide which definition controls?
Well, I think you have to look at what the parties originally intended. And if you look at paragraph 4.1, that's titled No Recourse Against Covered Persons, it states, hospital hereby acknowledges, understands, and agrees that payment for covered services will come from payers participating with PPO. With this understanding, hospital hereby agrees that under no circumstances will hospital bill, charge, or have any recourse against a covered person as specifically defined herein.
Right, so maybe that cuts the non-recourse provision out of the scope of 8.6 and says, for purposes of non-recourse, our definition in this PPO agreement, meaning you have to be an employee, controls. So we can have recourse against people who aren't employees. But that language about as specifically defined herein is not in the definition of, covered services in the PPO agreement.
But I think that to interpret this provision as saying only in 4.1 is, are you going to use the definition contained in the Mount Auburn
Because the
Prime
parties
contract?
specifically put language in 4.1 to do that.
But I think it wouldn't make sense because the whole purpose of that paragraph is to prevent individuals from recourse, and by limiting that specifically to only employees, but then saying everywhere else in the contract that covered person appears, it could be any person entitled to receive covered services under an automobile medical liability, automobile no fault, or general liability program, the definition contained in the Prime and AIS contract. You're leaving a huge number of individuals open to recourse, which completely defeats the intent of that paragraph. So I think what you have to look at is that Mount Auburn and Prime specifically put that language as specifically defined herein to demonstrate that they wanted and intended that their definition of covered person be used and not be replaced by definitions that might be set out in later contracts. And if a definition set out in a later contract were to replace the definition that's set out in the Mount Auburn Prime contract, that is essentially rewriting the contract, and the Mount Auburn Prime contract requires in paragraph 7 that any amendment be in writing and signed by both parties, and there's no evidence that that was done here.
Do you think it matters whether Commerce is an intended third-party beneficiary of the network access agreement?
I don't think it matters for purposes of this argument, because I think what's the most important point here is that the patients didn't qualify as covered persons. And so whether or not Commerce is an intended beneficiary, the patient's treatment still is not the type of treatment that would be subject to the discount that is referenced in this contract. And I understand Commerce argues that employees doesn't make sense in the context of the 3 contracts at issue, but there really is nothing wrong with the language when you look at it. Mount Auburn is to provide a 5% discount when covered services are provided to an employee receiving those services. They could easily have taken out the word employee or altered that language in some way, but they didn't, and their carefully chosen language must be enforced.
But then, what does 8.6 mean if it doesn't apply in this situation? When would it apply?
So there is a section in paragraph 3.3.1 of the Mount Auburn Prime contract, billing and claims processing. It sets out that the payer is to pay within 30 days of receipt of a complete claim unless they determine services are not covered services. And if they're not covered services, it says they will notify the PPO within 10 days, and then the PPO will forward to the hospital within 5 days. In the Prime and AIS contract, paragraph 3.4 says the payer will be notified of the responsibility to pay within 30 days of receipt of a complete claim unless within 15 days it notifies the participating provider that services are not covered services. So under the Mount Auburn Prime contract, a payer like Commerce is to notify the PPO like Prime within 10 days if services are not covered, and then the PPO Prime must notify the hospital within 5 days. But under the Prime AIS contract, a payer like Commerce must notify the...
You said you're contrasting 2 contracts. One is the PPO agreement between Mount Auburn and Prime, and the other is
The Prime and AIS contract, paragraph 3.4.
So the network access agreement.
Yes. And so in that one, the payer, Commerce, must notify the participating provider, like Mount Auburn, within 15 days. So this creates different rights and responsibilities of the parties. And so under paragraph 8.6, this is the type of situation where the language in the Prime and AIS contract would control. So the payer, Commerce, would be responsible for notifying the provider, Mount Auburn, directly within 15 days.
So what in 8.6 limits its application to non-material, non-essential, trivial administrative terms?
I'm sorry, could you?
What is there in 8.6 that says this conflict provision applies only to non-material, non-essential terms?
Well, it doesn't explicitly state that, but you can't read that paragraph to alter material terms set out in a contract, because those must be definite and certain so that the rights of the parties can be known at the time the contract was made, and they can't be subject to changing down the line that the parties would not know. They must be definite and certain.
I just have one. You don't address waiver at all in your brief, which I thought was odd. Do you agree that the lack of notice and the redaction claims that weren't raised in the district court are waived?
I would say that I didn't address them in the brief, correct? I don't know that they're necessarily waived because the court can look at everything now, but they aren't really issues that...
You can raise things on appeal for the first time that weren't raised in the trial court?
No, but the portions of the contract that we're all looking at, everything was before the court initially, and so when looking at the entire contract...
It wasn't raised as an issue. Neither of them were raised as issues for the judge to adjudicate and deal with. Okay, thank you. Thank you both. We'll take it under advisement. Our last case is 24P588, Department and Children and Families versus Mother. As you all know, this is partially impounded, so you won't use any names, use descriptive titles or pseudonyms or the like.
May it please the court, I'm Sherry Krasner here on behalf of the mother who is watching the argument on live stream. We're asking the court to vacate the judgment entered in the lower court. DCF's theory of the case was a vague and generalized notion that mother's cognitive impairments were a barrier to her ability to parent her child. The evidence, however, that they introduced in support of that theory was not clear and convincing, and the judge should not have so found. Moreover, DCF's own expert, who offered an opinion that mother would be fit to parent this child if she had the right supports in place. That is something that this court, in adoption of Chad, said a judge must consider. And it's also consistent with statutory law that the removal of a child from her biological parent should be something of last.
But is there any limit on what kinds of supports have to be considered? I mean, the expert in her report said she needs long-term, daily supervision by an adult with greater cognitive abilities. Does DCF have to consider providing that or provide it and see what happens before DCF can seek to terminate?
I would say yes. Chad doesn't put any limitations on it. The statute doesn't, talks about, again, that it being the last resort, and in this particular case, this living situation in which mother was in did offer or would offer those long-term supports.
Although it was unclear whether the child could live there, but the availability of supports is designed to eventually allow the mother to effectively parent or to return to fitness if she's currently unfit. Is this sort of ongoing support designed as or intended to be maintenance so that with this support for her whole life, the mother can be an effective parent? Or
for the child's whole life, until the child reached the age of majority. If that's what this mother needed to effectively parent, then I would say yes. The answer is yes. The fact that it would be until the child reached 18 and he was 3 years old at the time of trial, that's not the relevant consideration. If putting those supports in place would enable this mother to effectively parent her child, then the mother, consistent with adoption of Chad, could not be found unfit. But also, too, the judge didn't even get to that question or get to that consideration. I mean, he only mentions very briefly in two findings, finding 18 and finding 80, that mother was in a supportive housing at the time of trial. She'd already been there for 3 months. The DDS worker, the DDS worker, the DCF worker, and the worker from that provider agency, they'd met. They'd talk about the fact there was testimony they didn't want to be in silos. They wanted to work cooperatively to help this mother. But yet the judge makes no mention of that at all in his findings. He only talks about the fact that this mother didn't have long-term permanent housing and had housing issues in the past. So again, because he didn't even get to that question about whether mother could parent the child with those robust supports in place, I think that's a reason for this court.
Is that available in the mother's current placement at the time of trial? I thought there was some question about whether there was a room in which the child could be accommodated, and also some suggestion that the DCF was not allowed to inspect the house because the owners didn't want DCF anywhere near, or something like that.
Right. I saw that too in the judge's findings. I would refer the panel to my citations in pages 35 and 36 of my brief that seem to be inconsistent with that idea that DCF wasn't going to be able to come into the house. And while we would concede that there wasn't a room in that particular house, the agency that mother was living with, and this was the agency that the expert had recommended, could offer mother those kinds of long-term robust support. So even if in that particular house there might be an issue with a room, the fact that mother was now hooked up with this agency certainly suggested that there would be a placement for where mother could live, where the child could live, and where mother could continue to get the supports and be involved with DDS, with that agency, Hopewell, and with DCF. And again, too, the judge, he credited the opinion of this expert. And this expert, the only qualification the judge put on crediting the opinion was mother's ability to get to appointments on time. So the expert opined, and again, it was DCF's expert, not mother's expert, the expert opined that mother in that kind of setting would be able to parent the child. The judge says he's crediting her opinion, and yet he makes no mention of the fact that she was in precisely the setting that the expert had recommended. So there's just some confusion.
Can we just go back to the point of whether termination is not warranted where with long-term support the mother could be a fit parent? Factor 12 in the statute says that a court should consider a condition which is reasonably likely to continue for a prolonged indeterminate period, such as alcohol or drug addiction, mental deficiency, or mental illness, and the condition makes the parent or other person named in Section 2 unlikely to provide minimally acceptable care of the child. So doesn't the statute seem to say that if this unfitness is going to continue for a prolonged and indeterminate period, then, and the parent can't provide minimally acceptable care to the child unless the parent has these basically permanent supports until the child turns 18, that's a consideration that supports termination. I'm just trying to get at what, how far does DCF need to go?
I would say very far, and because termination is a very big deal, you're permanently severing the rights of a parent to parent her child, and condition, I mean, why would you have a trial? I mean, if you establish that someone has a long-term addiction or has a long-standing mental illness or a...
Because often there's some prospect of the parent improving, or at least there's an argument of that.
Right, but a parent who qualifies for services under DDS and has those cognitive impairments, that's a constant. That's not going to change. And the notion that we would simply say, okay, you have this condition and therefore we're going to terminate your rights, that's such an infringement on that parent's liberty interest when, with supports, and again, an expert, DCF's expert, opined that with those supports, that this mother would be able to successfully parent her child. And I think, although it's not a termination case, I think care and protection of Laurent that I cite in my brief is very relevant because this court said, well, there's always this residual, if you just focus on, well, what about this, and what if this happens, and what if mother can't respond to this, that you're always going to conclude, well, this parent can't do it, and that's just not the right analysis, that you have to, at some point say, if this mother with these supports is going to be able to provide care and the child is not at substantial risk, then it's error to terminate rights.
Aren't you kind of asking the judge, though, to sort of make a decision with a bit of a blindfold on here? Because it never became evident what exactly the mother's neurological condition or whatever condition was in play that even required DDS involvement.
Well, we know she had qualified for that service, and we know that DCF's expert, met with her over multiple times and also saw that there were some impairments. I'm not sure what, I think Your Honor, that you're talking about if the court had gotten the DDS records, that might have revealed?
He had, been enlightened
but-
somehow as to what are we dealing with here?
Yeah.
And how would this impact, if it would have any impact on her ability to be a parent? Maybe it wouldn't.
Yeah.
But maybe it would. So he's kind of in the dark,
Well,
isn't he?
I would suggest, I don't think having a diagnosis, which is probably what those records would have revealed, would have added that much to the judge's understanding or to DCF's understanding. I mean, the expert talked about how mother was very defensive about her limitation. I mean, I think that was a primary problem, is that she just became very defensive about what she perceived as something she was doing wrong. But understanding that, and I think those people who came in contact with mothers, such as the child's early intervention worker, such as her own individual therapist, such as the expert herself, who understood that working with mother and not putting her on the defensive would inure to everyone's benefit, particularly the child. And I think the DCF worker didn't evidence that understanding of mother's capabilities, and I think that put them at loggerheads a lot, and certainly had to do that whole issue of the day pass that I talk about in my brief, that the worker insisting that mother had to act in a certain way and do everything that the DCF worker said that she should do on the schedule that the DCF worker said she should, is what caused problems. And anything that were revealed in those records, I don't think would have added much to DCF's understanding or to or to the court's understanding. And again, I would talk about some of the cases I cited in my brief about parents with cognitive limitations. I talked about adoption of B, adoption of Chad, and adoption of Abigail, and I tried to distinguish all of those from the circumstances of this case. And in response, DCF, in its brief, talks about 2 unpublished cases, and so again, because they're unpublished, they're of limited value, but I would suggest that they're distinguishable from our case. One of the cases was adoption of Kenesha, and Justice Meade, you were on that panel, and in that case, the child had very complex medical and developmental needs, and the mother's health was very unstable. That's not the situation we have here. And also in that case, the mother didn't evidence any growth or change after her engagement in services. And again, though there wasn't a lot of growth, there certainly was growth. I mean, mother's ability to ask questions of the doctor and the clinicians at the growth clinic in this case showed growth on her part. The other case the DCF cites too is adoption of Opal. And the parent there, with her cognitive limitations, did not use any therapeutic or social services recommended when the child came into care. And before the child had come into care, mother had not brought her child to any medical, or not brought the child to all of her medical appointments. And again, here in this case, even though, mother was pushing back against what the growth clinic was saying, and, well, I'm small, the father of the child is small, the mother here, she did continue to bring the child to his appointments, and I think that's important for this court to consider.
In the limited time, isn't housing instability a legitimate consideration, and what was the mother's plan for paying for housing or obtaining suitable housing if she were reunified with the child?
Right. So mother did have housing. She'd been in the same housing for 4 months at the time of trial.
Right, but it was uncertain whether the child could live there.
Right. She had inquired. It was unclear what the answer was, but mother did have SSI, and she was her own payee, but she did have SSI, and the rules of the house, she had to use a certain amount of her monthly income would pay for her rent. So that was her plan.
You okay?
That was her plan.
All right, thank you.
Thank you very much. I'll rest on my brief.
Ms. Fierro.
Good morning. May it please the court. Assistant Attorney General Meredith Fierro on behalf of the department. I'm going to begin today by quoting from the portion of the expert report that my sister has invoked at least 4 or 5 times in her argument this morning. And I am on page 225 of the record. When asked, are there specific parenting skill deficits as related to child health, safety, and development, the expert witness opined that mothers capable of providing for child's basic needs with strong social support. However, she doesn't acknowledge that support is needed in caring for a child. Here, the judge correctly found that there was clear and convincing evidence that mother is unfit to parent child, based on the overwhelming evidence of the record that mother refuses to accept or even admit that she needs help in caring for the child. First, and perhaps most egregiously, the record shows that mother has put child's health at risk by refusing to follow the recommendation of healthcare providers. The evidence in the record is that mother denied that child was underweight in his diagnosis of failure to thrive, saying he was just small, was dismissive when a healthcare provider attempted to educate mother about feeding child more often, and dismissed the dietary plan recommended by the growth clinic as useless. In addition, there was testimony from a social worker that every month she recommended food for mother to bring for her visits with child, and that mother was also provided with a list of recommended foods by the growth clinic, but mother often brought no food or food that was not appropriately nutritious. Second, the record demonstrates that mother is not able and willing to provide a safe home environment for the child. Mother was offered multiple housing placements, but was removed from 3 different foster homes because of her behavior. She was first removed from a foster home in Dedham after threatening the host couple with a knife, leading her to her prosecution for assault and battery with a dangerous weapon. She was then removed from a shelter in Quincy for using marijuana, and then was later removed from a foster home in Roxbury for not matching with the caregiver and non-payment of rent. While mother has claimed today that she has secured housing for child, the evidence in the record is that it is a 1-bedroom. There was no evidence that there's a 2nd bedroom available for the child, that the host family was willing to take on the child. And there's also no evidence in the record that the host family would be willing to co-parent the child as specifically recommended by the expert witness. In addition, as Justice Sachs had pointed out, there was no evidence, or the social worker testified that she was not allowed to enter the home in which mother was staying, which is important here because 2 of mother's previous children, one of the reasons that they were removed from her care was because of the deplorable conditions of the home. Third, the record shows that mother simply would not do the work required to improve her parental skills, and again, that she refuses to admit that she needs to improve.
You know, this is a bit of a pet peeve of mine in DCF cases, that often the focus turns to, well, the mother won't accept the services that DCF says are necessary. And there are, I think, 3 of those that you point to in your brief. But really, doesn't the focus need to be on whether those services are, in fact, necessary to remedy specific deficits? So, for example, why does the refusal to disclose her intellectual disability make her unfit? Why does the failure to get a neuropsych evaluation render her unfit? Why does failure to take a parenting class render her unfit?
Sure. I'll start with the neurological examination. So I think it's important that the judge does not, mother tries to make much of her refusal to submit to this exam as part of the findings of unfitness. That's not what the judge relied on. If you look to the conclusion of Law 13 on disability, the judge specifically says that he was limited in the ability to take into account mother's disability because of just a lack of information about what it was. So the finding of unfitness did not rest on her intellectual disability to the extent that the lack of the psychological testing was mentioned in the conclusions of law. It simply went to the department's attempts to provide reasonable accommodations to mother. The department held an ADA, because mother did not disclose her disability, the department specifically held an ADA meeting for mother to try to find out what accommodations they could provide her, and she denied that she needed any accommodations other than increased visits.
So I think you just dealt with the refusal to disclose
Parenting class?
her disability and the neuropsych eval. What about the parenting?
Sure.
And you said that neither of those was
right.
a basis for unfitness.
Sure, I'll turn to that. So the nexus there is that the investigator, Maureen Sullivan-Trader, concluded that it is unlikely that mother would be able to consistently and safely parent child without consistent supervision and oversight. That's finding of fact 68 on.
She has a parenting aide, doesn't she? And there's some suggestion in mother's brief that she's not maybe, doesn't learn well from classes and requires one-on-one attention, which she seemed to be getting.
Well, the evidence in the record is that mother missed many of her parenting aid meetings. And on the parenting class specifically, that was not raised below that, the parenting classes, was not appropriate for mother and that she needed some sort of accommodation there. Again, the department did hold this ADA meeting to give mother that opportunity. And all she said was that she did not need parenting classes, not that that wasn't the appropriate venue or mechanism for her to learn. And in fact, the evidence is to the contrary. The expert witness who evaluated mother's parenting ability specifically recommended a specific parenting class. I think it was the Family Nurturing Center. This is in the record at the transcript, page 303. And the social worker referred mother to 4 different parenting classes, including that Family Nurturing Center class that the evaluator referred to. In addition, mother testified that she was taking virtual classes to complete her GED. But again, to the extent that mother is now claiming that there needs to be some accommodation for the parenting classes, that was waived below. I see my time is almost up. So to conclude, while the department does not contest mother's love for her child, given all the examples I just gave, as well as the evidence that mother often came unprepared for her visits with appropriate food, diapers, and wipes, the juvenile court did not abuse its discretion in finding mother to be unfit and, in fact, made the right decision. We ask the court to affirm the decision of the juvenile court.
One quick question. If the mother were reunified with the child, does her economic situation change in any way? Does she get AFDC or SNAP or some other benefit that she doesn't currently get?
That's not to my understanding is no. Mother's already receiving SNAP benefits as well as SSI. Thank you.
Ms. Lembo.
Anna Lembo, may it please the court. This is no doubt a sad case. There's no question the mother loves the child. She visited with the child. However, if she had only embraced services and gained insight through the course of this case, maybe we wouldn't be here. Unfortunately, she never was open to parenting classes. The social worker referred her to parenting classes four individual times. She didn't contest that this mother didn't feel she needed parenting classes. She described herself as a good parent, and the purpose of the parenting classes was to make DCF look good, to give her something to do. She never accepted the failure to thrive diagnosis before the child was placed, and even after the child was placed in foster care, going as far as into August of 2022. She still thinks the child is possibly just a midget, that she told the parenting capacity evaluator that she felt that he was losing weight due to illness. In fact, this child was 2 months old. Regarding his housing, she was living with the child in a Department of Developmental Services mentor home. So when she was living there, this child at 2 months old started to become failure to thrive. It was picked up by a pediatrician's appointment. She was referred while still living in that DDS mentor home. She was referred to the growth clinic. She was resistant with the pediatrician on direction on how to feed the child. With the growth clinic, she was focused on this child gaining a certain weight so she didn't have to go to the growth clinic. When this case went to trial in December 2023, the child was still being followed by the growth clinic. He'd made improvements in his weight, but he was still nonetheless prescribed appetite stimulants and still being followed. There were concerns. This mother did not want services prior to the child being placed, and after the child was placed, it continued. The nutrition plan, when the growth clinic was involved and the child was involved, before the placement, she stopped giving the child Pediasure. The recommendation of the growth clinic was that he take the Pediasure. She stopped it. When she was having supervised visits, she described the nutrition plan by the doctor as useless and pointless. She didn't want to follow it, and she didn't follow it. She bought her food at McDonald's. She bought her food at Burger King. She gave him nuggets. In December of 2023, she was having unsupervised visits, yet the parent aide was able to step in. On 2 occasions, one of the things the department wanted her to do is bring diapers, bring wipes, follow the nutrition plan. The parent aide in December of 23 was able to, the visits, I just give you a snapshot as to her ongoing unfitness, but in December 2023, the parent aide brought to the attention of the mother, she wasn't changing the diaper. It was not enough, she sometimes brought diapers, she sometimes didn't bring diapers or food, but she needed to act on it and change the child's diapers. She also, the parent aide in December also mentioned to the social worker, she had observed the child was just eating pretzels from Lunchables. She was still not making any improvement. This is not a cognitively delayed person. I know there's questions about to the extent of her cognitive delays. This mother didn't make it easy. This is not a cognitively delayed or impaired person that was accepting and embracing services. This was a woman who did not want services. Department, in addition to the parenting classes that she didn't want, referred her 4 times. They worked with her. The mother, they set up a parent aide for her. Most of the mother's interactions with the parent aide, the first one, there were 2 of them, she was referred twice, was by phone and by, I believe, email or text messages. She was ultimately discharged because she wasn't working with the parent aide. She made it clear she wanted help with the housing, is what she wanted. She didn't want help with becoming a better parent because she was already a good parent. She didn't need services, was always her attitude from the beginning, very, very beginning to the very end of this case. The second time around, she again did not work with the parent aide other than wanting to focus on that housing. On her housing, she did have housing the second time, and it was unclear as to whether she could bring that child. But that housing she had was a very short period of time. If you look at the entirety of this case, this woman, she had multiple Department of Developmental Services placements. She had one, there was an incident where she threatened them with a knife. She had another one in Roxbury, and for whatever reason, it was an incompatibility and an issue with rent. She lost that one. With the third one, it's not clear that she would have been successful even, in the context. She's bounced from place to place. In August of 2022, she was renting a room. DCF Department of Children and Family Services wanted to go in. She wouldn't allow them into that particular placement. She couch surfed for a period of time. In terms of DCF's assistance with this case, in July, the child was removed. In March, by July, they had a ADA meeting to see what accommodations they could provide. They invited the mother participated. She only asked for housing. She refused to provide any information about her disability to DCF, it was limited, to the court investigator, to the parenting aide. Regarding the parenting aide or the parenting capacity parenting capacity evaluator. With regard to that person, that recommendation was a qualified recommendation. The mother needed to demonstrate skills in improving her parenting. She needed to accept services, and she needed the robust services. It wasn't the robust living situation where someone was there that was higher functioning on a long-term basis. It was not just having that particular housing. If there are any questions, I would sum.
Seeing none, no.
Okay. Again, I'd suggest that it's a sad case. This mother never embraced services. I'd suggest the termination was warranted, and that it's in this child's best interest to remain in his pre-adoptive home. Thank you.
Thank you. Thank you all. We'll take it under advisement. With that, I'd like to thank my colleagues, the court staff, court officers, our clerk's office, our law clerks, and our time